Korean will be available on channel 1 of your translation devices, and English on channel 2. Thank you.
네, 오늘 행사에 참여해 주신 분들
Ladies and gentlemen, thank you for coming to the second day of the Moot trial. Before we begin, we'd like to ask for the participants to come to the stage for the official photo. We will first wait for the chamber to enter, and then afterwards there will be an official photo session.
for today's session. So when the judge is coming, we will take the photo together and start the session. Thank you. And 그리고 저 통역 장비를 갖고 계신 분들은 1번은 한국어 채널이고 2번이 영어 채널입니다. For the translation devices, channel 1.
This is channel 2. This is the English channel. We're testing English channel for channel 2.
It's at a diagonal.
You can, yeah. Your clicker is there. So whatever you want. 예, 오늘 행사에 사진 촬영을 하겠습니다. 사진 촬영에 참여하실 분들은 앞으로 나와주시면 감사하겠습니다. We're taking the photo of today's session, so please come out front if you want to take a picture together. Thank you.
지금부터 2024년 북한 정
Ladies and gentlemen, I would like to now begin the 2004 International Moot Tribunal on international crimes against humanity committed in North Korea's detention facilities.
Moot trial on crimes against humanity in North Korea's political prison camps will now begin. All rise, please. Please be seated.
Well, I will say again, good morning, ladies and gentlemen. Welcome back to this courtroom. I hereby declare the hearing resumed. Court officer, please call the case, please.
Thank you, Mr. President. We are sitting in a hearing session of the situation in the Democratic People's Republic of Korea in the case of the prosecutor versus Kim Jong-un, the supreme leader of the Democratic People's Republic of Korea, with charges of crimes against humanity in connection with the operation of the political prison camp system.
Okay, thank you. I would ask the parties to present closing argument. We will begin with the prosecution. Oh, sure. Right.
Good morning, and may it please the court. My name is Brian Tronick, and I will be speaking on behalf of the prosecution. I will first be setting forth our rebuttal of the defense arguments, addressing their arguments that Supreme Leader Kim Jong-un has not committed crimes against humanity in overseeing and operating the political prison camps in the Democratic People's Republic of Korea. And then after that, I will be setting forth our closing argument. So the defense argued in its opening statement that the existence of and the operations inside the political prison camps remain unverified, that satellite images cannot confirm the conditions inside the camps, and that the testimony that defectors are offering about North Korea and the camps are not impartial and possibly biased. I want to respond to that by saying that the existence of the camps has been widely verified by numerous independent and impartial bodies, such as the UN Commission of Inquiry, the UN Human Rights Council, and the UN General Assembly. There have been countless NGO reports about the camps, which are based not just on satellite imagery, but survivor testimonies, and the testimonies of former regime officials. We've heard from two of them yesterday. There have been thousands of independent media reports about the political prison camps, and actually just this month we had an admission during the Universal Periodic Review of North Korea by the UN Human Rights Council. Park Kwang-ho, the director of North Korea's Central Court, admitted that those who committed anti-state crimes were spies and terrorists, and they are not kept in the ordinary prisons, but in fact kept in reform institutions that are separate. So there we have a key admission actually just this month on this topic. Regarding witness impartiality and bias, first, there's no requirement under the Rome Statute that witnesses be perfectly impartial and neutral. In fact, I think it would be unrealistic and possibly cruel to expect a survivor of these political prisoner camps who have endured traumatic abuse of the kind we've all heard to be perfectly impartial and neutral when testifying about that abuse. The witnesses we heard from yesterday, many of them also expressed deep, deep sorrow and remorse that their relatives, their family members in North Korea may well be retaliated against in retaliation for their testimony. Yet they persevered and chose bravely to testify to highlight the abuses going on. So the defense argued in its opening statement that attempts to hold Kim Jong-un responsible for the crimes in these political prisoner camps is in a political attempt to impose foreign Western standards on the country. The defense argued that the international community lacks the legal authority to investigate and prosecute Kim for these alleged crimes, based on the principle of state sovereignty that we all know from international law and found in the UN Charter. However, I'll start by saying that the IMT has already concluded it has jurisdiction to hear this case under the Rome Statute. Importantly as well, as the UN Commission of Inquiry has stated and emphasized, state sovereignty is not a shield that can protect states from having its human rights record reviewed and evaluated in accordance with the treaties it itself has ratified. And in fact, ratifying a human rights treaty is actually an act of state sovereignty by affirmatively choosing to engage in this international human rights system. And in fact, the Democratic People's Republic of Korea has chosen to do so in an act of state sovereignty by becoming a state party to the International Covenant on Civil and Political Rights and the Convention Against Torture, which protect, among other rights, freedom of opinion and expression, the right to life, due process of law, and prohibits arbitrary detention, slavery, and discrimination, all at issue here. The defense in their brief they have cited several reports to make an analogy to between the North Korea's political prison camps and the perhaps poor prison conditions in other countries. And in fact, sure enough, there are reports saying overcrowding is a problem in other countries, in other prisons. And they have also cited similar reports to say, sure enough, deaths happen in other prisons in other countries. But this analogy doesn't ultimately work for several reasons. First of all, these reports, while they may document overcrowding and some deaths in other prisons in other countries, these reports do not document prison systems around the world where the very existence of the prisons is denied, where inmates are disappeared, where the operation of the prison is actually designed to slowly murder the prison population, and where prison guards are authorized and in fact can execute prisoners with no due process of law. And so it's not just that, but the scale of abuses in these reports pales in comparison to what we know about the political prison camps in North Korea. For example, these reports cite statistics like the ones I've shown you here. Police in Colombia killed 24 prisoners in an uprising protest. Rival gangs in Ecuador resulted in 79 deaths. None of that comes even remotely close to the numbers of deaths we've seen in the political prison camps in North Korea. So, and I'll be citing statistics on that soon. The defense also correctly points out that in some other countries, there are people subjected to prolonged pretrial detention where they are held, where they have not yet been adjudicated guilty, but yet nonetheless are detained for long periods of time. Nonetheless, that does nothing to undercut our claim that none of the 120,000 prisoners in the political prison camps in North Korea, they've never been charged, tried, convicted, or sentenced to prison. They've all been forcibly disappeared. And again, there's other key differences if we look at other countries compared to North Korea. The scale is different. Some of these reports point out that in Guantanamo Bay, Cuba, the US, has been detaining 19 men for more than 20 years without charge. Surely that is a human rights abuse, but nothing close to the 120,000 number we see in North Korea. And there's also a difference when we look at motivation or intention of extended pretrial detention or detention without trial. We know that many countries in the world have under-resourced judicial systems, and as a result of that, cannot try people in a timely manner. That is a far cry from what we see in North Korea, where the very system is intended to imprison people without trial. It's intended to kill them, not intended to just hold them until trial. The defense also pointed out in their briefs that other countries use the death penalty, some executing hundreds like Iran, 850 people in 2023. And also other countries have, in fact, engaged in torture. Yet again, that does nothing to address the problem in North Korea, where we've seen more than 400,000 deaths in the regime's political prisoner camps since the 1950s, and where thousands of the 120,000 current prisoners are dying from starvation, torture, forced labor, and other crimes against humanity. So the defense has argued throughout the trial and in their opening that Kim Jong-un is not responsible under a theory of command responsibility for the crimes against humanity, the alleged crimes against humanity in these political prison camps. I would remind the chamber that we've asserted two separate theories of command responsibility. The first is under Rome Statute, Article 28.1. Because there's no distinction in the DPRK between the military and civilian government. And so Kim Jong-un can be held responsible as a military leader or de facto military leader. But even separately from that, if the pretrial chamber does not conclude that he is a military commander or a de facto military commander, he can also be held liable under a theory of command responsibility under Article 28.2. as the leader of the civilian government who supervises the Minister of State Security and other key agencies that run the political prisoner camp and grossly abuse its detainees. And finally, the defense has argued that we are proposing a theory of accessory liability that is far beyond what has been accepted previously in international law. And they cite to cases from the ICTY and the ICTR where a commander did not, in fact, have sufficient command and control over local forces and therefore could not be held liable for whatever abuses occurred. Those cases notwithstanding, that is not the situation we have here. The evidence demonstrates that Kim Jong-un has an unprecedented level of command and control in the DPRK system of military and civilian government. And that is both formally, and what I mean by formally is his official roles in charge of specific agencies and bodies. But also informally, we know he has purged and executed hundreds of senior officials and even their family members who refused to follow his order. So even if he didn't have the official roles, he's intimidated all the government officials into blind obedience by literally killing them and their families. In addition, as I will soon describe, it is beyond dispute that Kim has direct knowledge of what is happening in these camps, of the severity, the scale, and the scope of the abuses. There have been decades of reports by the United Nations, national governments, NGOs, and the media. And in fact, there have been documented outreach by them to the government of North Korea seeking at least a comment, if not help in remediating the situation. And so there's no question he at least knows what is happening. I would also remind the tribunal of some of these international resolutions at the UN that Kim Jong-un and the government of North Korea would certainly know about. For example, in 2023, the UN General Assembly adopted a resolution on the situation of human rights in the country by consensus. That resolution stated, among other things, that the General Assembly, I'm looking at number 2 here, expresses very serious concern about the existence of an extensive system of political prison camps where a vast number of persons are deprived of their liberty and subjected to deplorable conditions. And then the General Assembly also urged the immediate closure of these camps. And so any claim that Kim Jong-un did not know that there were camps and that there were human rights violations going on, even as of 2023, doesn't hold up to scrutiny. Similarly, let's go back further in time. In 2015, there was a recorded vote at the UN General Assembly. It adopted a resolution overwhelmingly on a vote of 119 to 19 to 48. It has the same language, very similar language, where we have the very serious concern being expressed about the existence of an extensive system of political prisoner camps with deplorable conditions, alarming human rights violations are perpetrated. So again, we're going back nearly a decade where he's known, obviously, and in fact go back further to 2005 where we have the first UN General Assembly resolution on human rights in the country, which was also adopted overwhelmingly in favor with 88 countries. Again, we have the existence of a large number of prison camps and extensive use of forced labor. I'll remind the tribunal also that the UN Commission of Inquiry was created by consensus in 2013 by the Human Rights Council, which later accepted the Commission's report in a consensus resolution 2 years later. And then, I'll just remind the tribunal, I'm looking at the 3rd paragraph here, based on the body of testimony and information received, the Commission finds that DPRK authorities have committed and are committing, current as of 2015, crimes against humanity in the political prison camps, including all of the listed ones we have brought today. Finally, I'm going to present my closing argument, just summarizing our key points. So to step back a bit, reminder of the legal standard here. This is not a trial, right? We're in a pretrial chamber under Article 61.5 of the Rome Statute. The prosecutor shall support each charge with sufficient evidence to establish the grounds to believe that the person committed the crime charged. And importantly, I'll remind that we may rely on documentary or summary evidence, including the documentary evidence we have provided in our list of evidence to the pretrial chamber. So the prosecutor has charged Kim Jong-un with the commission of crimes against humanity on Article 7 of the Rome Statute for his oversight and operation of the political prison camps, including the crimes against humanity of murder, extermination, enslavement, imprisonment, torture, rape and other sexual violence, persecution on political, religious, or gender grounds, and enforced disappearance, with detailed evidence provided in the document containing the charges, the list of evidence and the reports therein, and the witness testimonies we all heard yesterday. Kim Jong-un has command responsibility under Article 28.1 and or 28.2 of the Rome Statute, because he has effective command, control, and authority over the Minister of National Security, who runs the political prisoner camps. He failed to exercise control. He knew or should have known about the crimes, and he failed to take the reasonable and necessary measures to prevent and repress the crimes. The attack in the form of the political prisoner camps is widespread, systematic, and directed against the civilian population of real or imagined opponents. And Kim Jong-un knows or should have known about the camps, given that he rules with an iron fist, and the scale and complexity of the system, as well as widespread public reporting by the UN, governments, NGOs, and media for more than 20 years, makes it impossible he doesn't know. So, based upon the prosecutor's opening statement, the document containing the charges, the presented documentary and summary evidence, the witness testimonies, the prosecutor's rebuttal of the defense's arguments, and the prosecutor's closing arguments, the prosecution respectfully requests the IMT pre-trial chamber confirm there is sufficient evidence to establish substantial grounds to believe that Supreme Leader Kim Jong-un has committed the crimes against humanity charged, and under Article 61(7)(a) of the Rome Statute, to commit him to a trial chamber for trial. Thank you.
Okay. Thank you. Thank you very much. Now I would revert to the representative of Defense Counsel to present their closing argument, please.
Thank you, Your Honor. May it please the court, distinguished guests, I rise to ask this tribunal not to commit this case for trial before a trial chamber. It is simply too early in the development of the case against Kim Jong-un for this case to move forward under Article 61. Kim Jong-un was born in 1984. In 1984, I myself was a high school student, just starting secondary school in the United States. And on the news each night with my family, I watched in horror the situation in South Korea as students and others fought for democracy. Eventually, of course, Park Jong-chul was tortured to death 3 kilometers from here, in a place which is now the Democracy and Human Rights Memorial Hall. President Chun Du-hwan was eventually tried, of course, but not for the death of Mr. Park. It was President Chun's policies, it was his security forces, and it was his torture facility, but he did not have individual or command liability for the death of Mr. Park. Fast forward 40 years. This year, in 2024, I myself have spent about 3 months at Naval Station Guantanamo Bay, operated by the United States military. According to the Special Rapporteur on protecting human rights in the context of countering terrorism, that facility has been characterized by incommunicado detention, 20 years of harsh conditions with no charges or trial for most of the men. It's been wrapped in secrecy, so it's been very difficult to obtain witnesses or evidence of what happens there. Reminiscent of the testimony we heard yesterday, the written documentation indicates there has been 1 UN visit there in 2023 who found the elements that I already explained. But does that mean that President Bush or President Obama or President Trump or President Biden are individually criminally liable for what occurs when they are the commander-in-chief? The question is whether they or any head of state has individual or command liability. And obviously in that situation they do not. Like those 2 situations, the same is true for Kim Jong-un. The participants in this International Moot Tribunal have done an extraordinary job. My friends, the prosecutors, have brought forth all the evidence that they could muster. The organizers have brought together activists and thought leaders and students and international jurists from across the world to witness this IMT. The court staff, and I want to especially mention the information technology staff and the interpreters have done an extraordinary job in making this possible. And of course, most importantly, the victims of horrible repression and after their escape to South Korea have bravely told their stories. They have documented a human rights catastrophe in North Korea, which demands attention from the international community. But demanding attention is not the same as individual or command responsibility under criminal law. The purpose of this proceeding is to separate cases which are ready to proceed to trial because they've had sufficient investigation from those which are not ready to proceed to trial. It's a screening mechanism. And given that prisons throughout the world are a human rights disaster, it's an important one because it draws a line between the responsibility of every head of state in every country in the world for the conduct of their prisons and those who themselves are directly involved in human rights abuses. Dr. Manho Pia testified yesterday about other political prisons. He testified about political prisons in Mongolia, in China, in Vietnam. The Kwangil are horrific. That evidence clearly established that. But so are many other situations in the world. They're not so they're horrible, but they're not so overcrowded as the Philippines with there we go. The not so overcrowded as the Philippines, with 3 to 6 people stuffed into cells for every available bed. Their trials may not be up to standards, but they did get a trial, contrary to the the prosecution's assertion, under the testimony of Mr. Lee Il-kyu yesterday, that sometimes the trials are closed, sometimes they involve national security, but they're still trials and investigations. That's different from, example, most of those who are imprisoned by the United States at Guantanamo, or in pretrial detention mandatorily for years and years in Mexico. It is horrific to imprison families, but is that really so much worse than the complete solitary confinement at a facility like the administrative supermax that the United States runs? The point is not who is worse than who. The point is that there must be individual or command liability. Okay. Thank you. Sure. The point is not whose human rights situation is worse than whose. The question instead is whether there is sufficient evidence to send this case to trial. Because sending it to trial without sufficient evidence is not in the best interests of the people who have bravely come forward. It may be true that a country is judged by the contents of its prisons, but it's not true that a head of state is judged by their prisons. Otherwise, the world order as we know it would end, because every head of state would be held responsible for the things which happened on their watch. Now, the prosecution in their opening statement promised evidence of Kim Jong-un's, quote, operation and oversight of the political prisons and their human rights abuses. Over all the testimony that we saw yesterday, that never came to pass. Mr. Kong Chul-hwan, for example, testified that he suffered horribly as a child in Yodok prison, but escaped in 1987 when Kim Jong-un was a toddler. Ms. Lee Byung-lim testified about the documents she found in 2 cases in the office of Kim Jong-il in 1977, before Kim Jong-un was born. Now, individual criminal liability under Article 25 or command responsibility under Article 28 requires more. I will note for the tribunal that there is one dispute over the charging liability. The government argued in its opening and closing statements that it had invoked Article 28 Bravo B involving civilian command liability. I invite the tribunal to scour the charging document for any reference to Article 28B. It charges only 28A. The relying on Prosecutor versus Bemba. Prosecutor versus Bemba clearly dealt only with military command responsibility. And I invite the attention of the tribunal to paragraph 406. That's important because there's no evidence of abuses by the military. If this is a military command responsibility, the prosecution must fail. The testimony from Kim Jong-un said, which is the only testimony about the involvement of the armed forces, said that the armed forces were responsible for the exterior security in the revolutionizing zone, not the abuses which occurred within by the civilian MSS authorities. But even under Article 28B, civilian command responsibility, there's simply not enough evidence to demonstrate the level of responsibility which is required to impose criminal sanctions. Compare that to other situations. In the Akayesu case, Mr. Akayesu was convicted as an on-the-ground leader who was personally directing atrocities to take place. Now, one of the most prominent modern cases about prison and detention facility abuses is the Celebici case. And in the Celebici case, Mr. Delalich was acquitted because he did not have sufficient command and control over the forces which were actually committing the abuses. Now, the Celebici case is the one that Dr. Hieu testified about yesterday. He called it the Kosovo situation. And he said that in that situation, there was an acquittal because there was no evidence of direct orders. And he candidly testified that, quote, "We may never find evidence of Kim Jong-un's involvement." Now, the high watermark for the prosecution is that Kim Jong-un has the final authority on sentencing matters which come before the courts in political cases. It's not easy to believe that Kim Jong-un had personal sign-off on 116,000 prisoner cases. But accepting that is true for this time, how is that different from most systems in the world? In most systems in the world, the executive leader has final sign-off on many forms of sentencing. In the United States, for example, the United States president has the final authority on military sentences, is the final person who must approve them. In the United States, in federal civilian cases, the US president has the pardon power, is the final decision on whether a person will serve their sentence or not. The idea that a leader would have final authority on a sentence is a protection, not a crime. Now, instead of the operation and oversight that the prosecution promised, what they have offered instead is assumptions. Mr. Kung testified, for example, that because no one really knew, we could only imagine what was happening in the total control zones. Ms. Lee testified that she assumed that Kim Jong-un had the same work habits as his father, Kim Jong-il. Mr. Hugh testified that he believed that Kim Jong-un had micromanagerial control, and his evidence was that Mr. Kim Jong-un's father, Kim Jong-il, had approved the bus that actresses had to change in for a movie to be made. These are not the facts on which criminal liability is based. And the most serious assumption that the prosecution invites this tribunal to make is that the abuses of the camps are so open and notorious within North Korea that it must be true that the defendant personally directed them. But that's contradicted by the actual evidence which came before the tribunal. Lee Il-kyu testified that he was highly placed in the Ministry of Foreign Affairs, but that he didn't know of the human rights abuses in the camps. Mr. Kim Kuk-sung testified that he was highly placed in the intelligence community with massive cross-reporting from the MSS. But he never thought, in his words, about the prison camps or human rights abuses. He only learned that Kim Jong-un was not the human being that he thought he was after a 1913 power struggle in which a friend of his was executed. Mr. Kim testified that, in fact, to the opposite of the prosecution's assumption. He testified that abuses, human rights abuses, would not be reported up the chain for fear of angering the supreme leader. Ms. Lee, with access to the private papers of Kim Jong-il, testified that she didn't think ill of the DPRK until after the 2009 currency reforms. And neither Kim Jong-un nor the friend who sent her to the Yodok concentration camp had any idea of the suffering there. In fact, she testified that she didn't even know what a concentration camp was. This testimony illustrates the risk of making assumptions on incomplete evidence. In their opening statement, the prosecution argued that there were 4 political prison camps, 14, 16, 18, and 25. But on the redirect examination of Mr. Kung, the prosecution elicited that Camp 18 was not, in fact, a political camp, and it did not hold political prisoners, but rather ones who had committed economic crimes. Where does the truth lie? I don't know. But that sort of inconclusive evidence is not the basis for criminal liability. Now, both parties have mentioned earlier that Article 61 proceedings have the purpose of determining the readiness for trial. If the tribunal disconfirms the charges, it's not a rejection of the suffering of the brave victims who have testified here today. Instead, disconfirming these charges is a call to action, a notice that there needs to be more research, more investigation, more work, more attention given to this critical issue. Dr. Hyo testified that, quote, "We have limited information, but we can't do anything about that." Dr. Hyo is a testament to the work, to the lifetime of work that many people have given to this critical issue. And as people of faith and hope, we have to believe that it is not true that there's nothing we can do. In fact, this International Moot Tribunal is itself an example of doing further work on the question of whether Kim Jong-un can be held criminally responsible for the abuses which have taken place in prison camps. More brave people, like the men and women who testified at serious risks themselves, will come forward. There will be more acts of heroism, like the publication of directives by the Workers' Party that Mr. Kung testified about. Could those documents shed light on this situation? Perhaps. The prosecution didn't bring them forward, but it may be that those documents and documents like them will eventually bring the evidence to the place it needs to proceed to trial. There will be more courageous acts, like that of Mr. Lee, who released foreign ministry telegrams. Those telegrams explained the North Korean strategy of using consensus votes instead of numbered votes. They weren't about prison camps, but maybe the next disclosure will be about prison camps. And finally, maybe there are more opportunities like the Universal Periodic Review that Mr. Lee testified about. That UPR statement turned out to deny rather than to confirm the existence of Kwangil, stating that there were separate national security prosecutions and prisons. But maybe a future UN special mechanism or a future UN investigation will shed more light on the personal responsibility of Kim Jong-un. The UN resolutions that the prosecution brought forward address the country and not the person. Now, it may be, as Dr. Hugh testified, that we may never find evidence of Kim Jong-un's involvement in prison camp abuses. But while there is life, there is hope. We respectfully ask the tribunal to disconfirm the charges, which will be a call to action for men and women of faith, hope, and bravery to find the evidence needed for this case to eventually go to trial. Thank you very much.
Thank you. Thank you, Defense Counsel. The bench will now leave the courtroom to proceed with our deliberation in our chambers. You are permitted to leave the courtroom, but I ask you all to be present in order to recommence at 1 p.m. You have a lunch and have free time, and thank you. I thank you all.
All rise, please. Please be seated.
Texted my wife this morning. I'm like so worried that we're going to win.
번째 사이드 이벤트를 잠시 뒤에 시작하겠습니다.
Ladies and gentlemen, we're soon to begin the second side event session.
네, 이제 사이드 이벤트 첫 번째 세션 시작하겠습니다. 지금의 사이드 이벤트는 이제 200
Ladies and gentlemen, now we're ready to begin the second session. This is a side event. We invite the two presenters to the podium for the presentation. Mr. Cho Jong-un and Mr. Chang Won-jae will be the two presenters. Regarding the proceeding of today's side event, I'd like to invite President Kim Tae-hoon to deliver the introductory remarks.
네, 안녕하십니까.
Good morning, ladies and gentlemen. We've gathered here since yesterday to look into the issue of crimes against humanity committed in North Korea's detention facilities. And this is a Moot trial on the international crimes against humanity committed in North Korea's detention facilities. And we've just heard the closing arguments of the prosecutor and the defense attorneys. And now the judges are deliberating in a separate room. And as they announced, as they exited, the chamber is going to complete the deliberation. So we ask you to come back to this venue at 1 p.m. And the chamber is going to make a rendering. And in the time being, I thought that it might be very important we attend to this event, this very important event. This event relates to the background of us coming up with this IMT, the Moot trial. This is a Tuesday, and we have had Tuesdays gathering every week, and so this is the 286th session of the Tuesday gathering. So at this side event, we are going to look into the background information for the establishment of the IMT. So we don't go back to the ancient era, but we have seen quite a lot of international crimes committed in the modern and the contemporary era. So we've invited the nation's expert on this issue, Professor of Hankuk University of the Foreign Studies. He's the nation's expert on this issue. And also Chang Won-jae is another expert on this very important issue. He has extensively covered the Khmer Rouge, who are the culprits behind the killing of people in Cambodia. He has contributed to many different articles in the monthly Joseon and other media. And the horrendous crimes committed in the international scene, how the international community has responded to such atrocities, will be the main topic to be discussed by Dr. Won-jae Chang. He's going to focus on the Khmer Rouge. He's going to give us a presentation with extensive data that he has collected over the years. So, since we have quite a lot of time, we have distinguished participants here with us today. I'd like to make introduction of some of the guests here today, and those who have participated from the very first days of the Tuesday's gathering, 화요집회. So let me introduce the VIPs. And we'd like to invite them to give us a few minutes of speech. First to be introduced is Vice Minister of Unification Kim Seok-gu. He is now the president of the NKHR, the Citizens Coalition for Human Rights in North Korea. We invite him to the podium to give us a very brief speech, or perhaps at the end. So President Kim Jong-un, we'd like to ask you to do that later. Bae Byung-ho is the Secretary General of the Human Rights of the Elderly in Korea. Oh Kyo-hwan, Elder. There are many more guests to be introduced. There are many distinguished pastors here. And we'd like to ask him to give us very brief introductory speeches later, but for the time being, we'd like to first proceed with the presentations. We ask Professor Cho Jung-hyun to begin the presentation.
예, 안녕하십니까.
Good morning, ladies and gentlemen. My name is Cho Jung-hyun, a professor at the Law School of Hankuk University of Foreign Studies. It's a great honor for me to be able to present before such a distinguished audience here today. In year 2000, there was an IMT held for the war crimes of Japan against sex slavery of women in Tokyo. I attended the IMT as a student at the time, and it is really an overwhelming experience for me to see that an IMT is now being held in Seoul, Korea, on this topic of international crime against Kim Jong-un. I'd like to extend my appreciation and my respect to Mr. Kim Tae-hoon and his staff for making this possible. I'd like to give an introduction of the international law and international trials and how the crimes, international crimes, are appraised, assessed in. So let me just skip out. This is actually an introductory image slide for which I do during my presentation all the time. If you look at state-to-state relations, the international law governs the state-to-state relations. If you think about the United Kingdom, what is a state? In the FIFA World Cup, the United Kingdom is divided into different countries: Scotland, England, Wales, and Northern Ireland. In the 2018 Olympics, the United Kingdom participated as the Great Britain. It did not participate as the EN, England or Scotland, but in the United Nations, it participates under the banner of the United Kingdom. So what is a state? How do you define a state? To give you the heads up to conclusions first, at the FIFA or at the IOC, a state participates in competitions, but in the sports competitions, there are some unique peculiarities to be considered, and therefore some countries are allowed, states are allowed to participate under different names. But if you look at what is coded in the color red, blue, green, and light green, these are the four segments of the United Kingdom of Great Britain and Northern Ireland. So, as an permanent member of the United Nations Security Council, the United Kingdom participates. And also there's Republic of Ireland and Northern Ireland. These are two different entities. One color-coded in white is Republic of Ireland. It's a country that has gained independence through blood, by shedding blood through a war. The Northern Ireland, on the other hand, is a part of the United Kingdom. United Kingdom is not a federation, therefore it is not a state. It's like United States, Canada, and these are the British Commonwealth. It could be the British Commonwealth, but this is like, it's called a country. It could be regarded as a province. I studied in Edinburgh myself. I met Irish friends, and they used to tell me that we are also a divided country, and so are you. Think of countries like Sierra Leone and Cyprus. They are separated, divided nation, but in a different sense. They're divided into two different nations. Ireland is divided into an independent state and a constituent of the United Kingdom. So, coming back to the main body of my presentation, international law governs state-to-state relations. Nation is a little different from state. Nation is more national, something of a people. So it's national is like for the people and certain people. So state is more closer in describing what I mean by the 국가. So coming back. Individuals has not been handled extensively under the international public law because it covered the state-to-state relations. It has, on rare occasions, dealt with the individual issues when it came to the war crimes in Japan. And of course, there have been the combatants and non-combatants, or the combatants were not willing to fight. On how they should be protected as human beings has been also discussed in the international law. And that's what was covered under the IHL. But then again, the scope was expanded. And the expansion of the scope has led to the emergence of international organizations. ICC is definitely an international organization. This is a legal entity different from the United Nations. But it has entered into a special treaty to enter into cooperative relations with the United Nations. The same is the case with WTO. As an entity, as an international organization, it is governed by international. The international individuals are governed by the international law. Then, how does the human rights emerge? I think it first appeared in the International League days. Under the ILO. In the international documents, human rights was not officially recognized. Under the Versailles Treaty, if you look at the content, the Bolshevik Revolution in Russia emerged in 1909, and after the First World War, the people were very conscious about the slavery. And ILO was very conscious of the protection of the laborers. And there has been discussions about the protection of the minorities. And this has led to the refugees protection. And in the early 20th century, the refugees are not individuals, but they were regarded as a group, collective group, perhaps something like a treaty to protect Armenians that have fled the persecutions of the Turkish. So these are the kind of refugees that have been protected during this time. And then, under the current system, which is the UN system, after the World War II, after the United Nations were inaugurated, there's been discussions on the protection of the human rights. And as you know very well, the Nazi regime persecuted and exterminated the Jews and also the sexual minorities, those with physical disabilities, and also gypsies, who are also known as Romans. They have been put under great persecution. And the representative case was, of course, the Jews. It's not that they were subject to some criminal charges or some wrongdoings, and they have been persecuted because of their racial backgrounds and religious backgrounds, and they were put into gas chambers and were killed in massive numbers, and they were put into prison camps along with their families, and they were put into physical examinations and tests. Harsh things have been done to the Jews. So who are the Jews? What nationalities did they hold? Was it a national issue or international issue? As you know very well, at the time during the World War II, Israel was inaugurated only in 1948. Therefore, Israel did not exist. And the Israelis, the Jews that they were persecuted largely by the Nazi regime, were held German citizenships. And when the Nazis attacked neighboring countries, it could be the other nationals, but nationality-wise, legal-wise, many of the Jews that have been persecuted held German passports. Only they were different in racial background and religion.
국제 문제가 아니었죠. 전통적으로
Traditionally, this could be something, a jurisdiction to be exercised by a national court with exclusive sovereignty. This was regarded as domestic affair. So this was not really an issue that should be mentioned by foreign countries. That is how the international law interprets in the past. But at the end of the World War II, because of this massacre, the Holocaust, people came to understand that what has been traditionally regarded as a domestic issue, about something to be handled by a domestic national government, is no longer a national issue. International community need to pay close attention to an issue of such gravity like this. So there was a change in perception, and that is how human rights came to be first included in UN treaty, UN documents. There are basically two different approaches. The first one is human rights-based approach. This is the declaration, human rights declarations, and this is a Universal Declaration of Human Rights adopted as an annex to the UN G8 document in 1948, and this includes many the UN ICCR and ICCPR and other related documents. And U.S. and the United Nations still had the colonies, and therefore there are many different issues involved. So the international documents did not, although it's included in the international declarations, the treaties did not include those documents. So this is not legally binding. And of course, you have to bear in mind that the Universal Declaration of the Human Rights is still recognized, and this has become an international customs law. So it is a UN General Assembly adopted resolution, so but no matter, it is regarded as international law. So treaty law and customary laws are both regarded as international law. Now let's look at the legally binding the aspects. As I mentioned, these are the ICCR, ICCPR, and there are many UN Security Council and Advisory Council related documents. There are many different committees on the torture against the exclusions of women and children's rights. So these are basically treaty-based mechanisms and charter-based mechanisms. These two mechanisms work together to establish the international human rights law. And then there is international criminal law. As you know very well, in Europe, after the defeat of Germany, the end of World War II, the Nuremberg, the international the military tribunal was established, and 1 year later, the Pacific War came to an end, and the Tokyo, the international military tribunal of the Far East was established, and it is for the first time that crimes against humanity was included, and of course. There was a criticism that it is like a backdating of the backdating applications of the laws, but still it regards that the crimes against humanity has been first recognized for the first time in this international military tribunals to be included in the international criminal law. So how individuals are dealt has not been discussed because previously this is regarded as domestic affairs. Domestic means home as well as the national. At the For example, if there's like domestic violence, if a husband has hit the wife, he will be subject to criminal persecutions even if it happens internally at home. Likewise, if there's like a serious infringement of human rights, then they will be regarded as an universal right, an infringement of the universal right, and so anybody can argue for penalties to be imposed. Nationals may be powerless, and therefore this is a responsibility for all. Any country make a legal standing, make legal claims for infringement of serious human rights abuses domestically. Now, the genocide is a crimes against humanity, which is what we're discussing mainly today. That can be an internal issue. For example, international crime was usually a war crime. War crime requires a belligerent country A and B. But these days, civil war is also subject to the international war crimes. So usually, international warfare is about warfare between states and state. Now, the international criminals include individuals as well as a state. International criminal law was came about at the time when the war between the states as well as the genocide and crimes against humanity against individuals began to occur. So previously, this has been regarded as a domestic issue. Other countries are not able to make a claim about this infringement of such rights. So previously, what has been recognized as domestic law has now been expanded into international law. And there's been discussions about the infringements of the human rights and the humanity, crimes against humanity, and that the scope of the international criminal law has been expanded to include that as well. IHL is actually a new name for the crimes, the law against the crimes, because the United Nations has banned wars. Therefore, it refrained from using the term international war-related laws. So IHL is actually a new name for the previously in the law governing wars. It also governs wars between states in the past, and now it also includes civil wars. In the Geneva Conventions, there's a mention about civil wars, but after the 1978 additional protocol has been included, non-intentional conflict has been included, and so explicitly, since 1977, the civil law is civil war-related provisions are included, and all of what I mentioned are included in the Rome Statute, and it is on the basis of the Rome Statute that we are now proceeding with the IMT. I don't want to mention too long about R2P, the responsibility to protect. This is all related to international crimes. The international community seeks to look at the sovereign states which have the first R2P. When a sovereign state does not fully implement the responsibility to protect, but instead it becomes a perpetrator, then the international community will take actions to sanction the sovereign country. So the ideal thing is that sovereign states play its role, but when there is a manifestedly failed the status, then the international community will take actions. They could take coercive actions, but they could also resort to various different means, including referring the case to the International Court, because only the UN Security Council can reviewed refer the case to the international UN Security Council, and therefore the things related to R2P is that something that related to the human rights issue, so it has been actively discussed as well. This relates to a photo of the protest in Myanmar. How did people come to recognize R2P? Myanmar is under a civil war status. I'm not sure if you remember the Myanmar status. I'd like to draw your attention to the situation in Myanmar, or the situation in Hong Kong, or the Xinjiang, the Uyghur, or the Palestine. These are many countries that still require our attention when it comes to international human rights infringement. Now, there are basically two ways of looking at the regime, and I think UPR, in the UPR, the UN, the North Korea tends to be quite cooperative, and these are some of the treaties I like to pay attention to. But let me skip this slide because I don't need to describe in detail about each treaty. These are some of the human rights regime. The treaty-based mechanisms I want to mention for North Korea. For every 4 years, every 5 years, a sovereign country is to report to the UPR. UN Security Council, or UN Human Rights Council, excuse me, looks at the UPR. This is a periodic review. This is a review between states. Of course, NGOs can participate, but basically this is a review between the states. And the committees also looks at the human rights, and the human rights issues are reviewed by individual experts. Experts submit documents, and then documents will be reviewed. So it could handle a little more the content with more expertise. These are the voluntary participation in the treaties. For example, when it comes to CEDAW and CRC, they submit reports, but for the rights of the disabilities, they submitted a document quite recently, but no report was submitted related to the ICSSCI. Now I'd like to talk more about the criminal enforcement and the international scene. There have been efforts in the past after the World War I. According to the Versailles Treaty of 1919, Article 227 and 228 makes a definition. The former German Emperor Wilhelm II was referred to be indicted. And it did not happen. Instead, at the Leipzig Supreme Court, 13 people have been indicted, and 6 have been acquitted. Others have been 7 have been acquitted, and 6 has been convicted guilty. After World War II, there have been IMTs, and the Nuremberg, and also in the Far East in Tokyo. Crimes against peace has been applied in these 2 tribunals. I think this is for the crimes against aggression. So it began with crimes as peace, and also war crimes emerged for the first time at these tribunals. Crimes against peace is about a country attacking another. So this is international. But if you think about the crimes against humanity, this can be domestic and international. War crimes is actually international. This is a war crime of one country against another country. For the crimes against humanity, this can also be domestic. So the domestic concept was included. So there's a lot of disputes over the retroactive application and other things. And so the crimes against humanity looks at the customary laws, and it has codified the customary laws that existed in the past. The Nuremberg trial convicted 19 guilty, and in Tokyo, 23 were convicted guilty. 1 year later, the Tokyo tribunal began, but because of the Cold War, the Soviet Union tried to expand the communism, in places after the war. But because of the strategic value that Japan had for the United States, because of the change in stance by the Soviet Union, the United States has decided to close the tribunal quite at an early date. But still, having 3 people sentenced guilty is quite an achievement. Now, moving on with the emergence of the Cold War. At the time, there have been efforts to make these ad hoc tribunals into permanent organizations, and also the Human Rights Treaty was also sought. But because of that, the Human Rights Treaty draft was broke down into two different treaties, ICSSCR and ICCPR, and some 40 years passed since then, and during the post-Cold War era, in the Eastern Europe, there have been many different new states established, and there was a civil war in Bosnia. And to deal with the very serious situations in the Bosnia, an international tribunal was established. ICTY was established in 1993 to deal with the situation in the former Yugoslavia. In 1994, to deal with the situation in Rwanda, ICTR was established. So ICTY and ICTR have been established by the United Nations. It's been not decided by a consensus of the related parties. So comparing the two together, you will see the previous two and these two together. In the past, in the Nuremberg and Tokyo, it was crimes against peace, war crimes, and crimes against humanity. Now in Yugo and the former Yugoslavia and Rwanda, it's war crimes, genocides, and crimes against humanity. Instead of war crimes, the genocide concept was introduced. Genocide Convention was established in the past. I told you the International Tribunal was established in 1945, but the Genocide Convention was concluded in 1948, so it came after the first tribunal. And that's why genocide concept was introduced for the first time in the 1990s. There's been a lot of disputes about what constitutes the aggression, and therefore the crimes against aggression concept was included later. So at the time, it has been decided crimes against the peace will not be included because it's a highly disputed item, but instead it will include the genocide concept, which was first introduced in 1948. The ICTY sentenced 90 people guilty, and while the ICTR concluded 62 people to be guilty. And we don't have ad hoc tribunals. We don't need ad hoc tribunals anymore. So these tribunals have been concluded. And ICC was established as a permanent body according to the Rome Statute of 1998, and it was established 4 years later in 2002. And after it was established, it has jurisdictions. So ICC does not have jurisdiction for any instance that occurred before 2002. It looks at crimes as part of its jurisdiction. The 3 ad hoc tribunals plus the crimes of aggression, which came about 16 years later in 2018. So these are 3 plus the crimes of aggression. A war of aggression is an example very quite difficult to find in the United Nations because UN does not recognize wars. And the UN Security Council may sanction one, and there could be special cases. There could be Korean wars, there could be Vietnam War, but the international war has not occurred after in the latter part of the 20th century. So this is a very rare era in that we don't have international wars. But more regretfully, we're looking at the war in Ukraine, which is a UN Security Council permanent member attacking its neighboring country. It's not like the United States attacking another country and acquiring the land. The United States, after that, has returned to its own country. But so the Russia is now attacking another country. There's a likelihood that Putin may become a criminal under the ICC, but Russia is not a constituent of the signatory of the Rome Statute. For a crime of aggression to occur, all the stakeholders, those who have been attacked and the attackers, need to be signatory to the Rome Statute. If let's look at the case of the Ukraine. After the Crimea, I don't know why Ukraine chose to become a signatory, but after the 2014, Ukraine has recognized the jurisdiction of the ICC after 2014. So what happened in Donbas region, the forced migration of children to the Russian territory, ICC had issued a warrant to arrest Putin and the person responsible for the migration of the children, because this is a part of the ICC jurisdiction. ICC can issue a warrant, but the crime of aggression is a different issue. On the crimes of aggression, there is a prerequisite which makes it a must for the two countries to be a signatory to the Rome Statute, and they aren't. And therefore, for the war in Ukraine, we won't be able to apply the crime of aggression. And then moving on, I am looking forward to listening to the presentation by the next presenter, but there is a hybrid court or the mixed tribunal. And this is basically something of a mixed nature. So the international law may apply, international criminal law may apply, and domestic criminal law may apply as well. And foreign judges may participate, and also domestic judges can participate. There's a case of the Sierra Leone and Cambodia. It comes in different forms, and therefore these mixed tribunals have been established in more than 10 occasions. But this is actually not to be confused with the previous one that I mentioned. The hybrid court requires consent of the host country. For example, there's been serious infringement to human rights or the military, the violent the suppression of some the protests. With the close cooperation of the United Nations, the host country that may choose to establish a mixed tribunal. This cannot be established by force. In countries like Rwanda, it has been established with or without the will of the host government. But for the mixed tribunal, it has to obtain the approval of the host government, meaning the government of the territory involved. There are many different cases of violations of the criminal laws in the domestic and international scenes, and the criminals can be, the accused can be brought to court and sentenced. This one relates to the killing fields of Cambodia. So the crimes against humanity has been specifically mentioned, and sentencing has been done. The accused have been tried and sentenced to be guilty. And this relates to the human rights situation of North Korea. I think this is very important because If you think about the South Korean government, if the South Korean government is going to pursue a process of reunification, and also at the same time it wants to put the offenders and the person in charges to court, the South Korean government may likely want to play a very main role in the chamber, and it may want to arrest the perpetrators. It may want to secure documents. It may want to investigate. It may want to indict. It may be in a favorable position, but there are evidentiary rules. We enforce very strict evidentiary rules. So domestic, the criminal courts requires the attorneys to jump many different hurdles. For example, one is assumed innocent unless proven guilty. So the individual is regarded innocent unless proven guilty. And providing evidence for that is a very daunting challenge. You need to come up with hard evidence. One is declared not guilty does not mean that one is innocent. But what about international court? In the international court, when there's like a massive human rights violation, this is very different from the domestic court. It cannot look into each and every one of the documents. For example, you could have hearsay evidence. Hearsay evidence is usually not admissible in domestic courts. But in ICC and international tribunals, hearsay evidence may be adopted by discretion of the chamber. And indeed, crimes against humanity, this has been recognized many times by the chamber. Now, the people say that in the domestic scene, in the domestic players, people may think that we may not be able to play a major role if ICC takes control. Now, the answer for people who worry about this may lie in the hybrid court, because a hybrid court can be pursued to apply international criminal law and also domestic law. And the evidentiary rules may be decided by looking at different the courts and adopted. This is not an international or domestic law. It's a hybrid system, and therefore the chamber may consent to certain evidentiary rules, such as recognizing hearsay evidence. You can look at good precedent cases in the past, and this cannot be done quite easily in the domestic courts, and therefore mixed courts can be quite beneficial. As Cambodia is a case in point, and I think we are going to listen to a presentation on the Cambodian case. We need to look very closely into the Cambodian case for its possible application in Korea later.
북한 인권 문제를 그래도 오늘 이제 실컷 어제 오늘 하실 텐데
네.
그래도 간단하게만 제가 뭐 그거를 오늘 설명해달라고 제가 요청받은 건 아니기 때문에 간단하게만 그냥 방금 설명드린 그 내용에 어떻게 적용되는지만 간단하게 보고 마무리하도록 하겠습니다. 기본적으로
how this can be applied to the domestic cases in South Korea. Now looking at the COI, it was established, and COI issued a report in 2013, and it discussed crimes against humanity. There's a request to look into the crimes against humanity and report. This is a very rare case because this is one of the two frameworks, and this is under the UN Human Rights the framework. And this entity is called For Crimes Against Humanity, which means criminal law application. It usually doesn't do that, but in the 10 years since 2003, since the first resolution at the UN Human Rights Council and a resolution at the UNGA, the efforts began in 2003 in Geneva, and then the resolutions have been passed in the UN General Assembly as well. So this is a continuation of this parallel movement, and then 10 years have passed, and we recognize that human rights situation cannot be improved by dialogue, the basic framework. So with this reflection, the United Nations wanted to pursue a different means, which is considerations of the criminal law application possibility. And that is why crimes against humanity was included. So we look at many different the ICSCR related rights. And there's been talks about the political prisoners. Of course, the political prison camp, once you're admitted, the likelihood of surviving the prison camp is very low. And therefore, the number of the prison inmates are likely to decrease. This is because of the deaths that occur within it. For example, for a religious persecutions, religious members may be persecuted into the prison camps, and then the number is going to dwindle. So the number of the prisons, the population decreasing is not an indicator of improvement of the civil rights. At the UPR also included the possibility of the admission of the political prison camp, Kwangil. We need to closely look into this issue to see what it means. And there's been also this mention about public execution. There was a new law acted about the public that recognizes the public persecution. That was included in the UPR as well. I was very surprised to see that because a normal state new normal state will include the public execution in a legal provision. This is actually the first time that I see it in a state. In the past, you see that the public executions may have been carried out, but it's not according to the law. But this is a law related to the control of ideological control of the populace, and it includes such a provision, the recognition of a public execution, and this is such a setback. And the public execution is not really about your right to life. This relates more to the inhumane treatment of the audience or the family members. The right to life is not really much violation of the right to life, because life is deprived of through the executions. It's not just that. What's more important is that the inhumane act is being conducted upon the audience and the family members. We see that human rights situation is significantly deteriorating because in the past, when they revised the constitutions and laws, they tended to improve. But these days, they make a notable the setbacks. And we see deterioration of the situations in North Korea in legal aspects. So I'm looking at these 9 patterns. Political prison camps and also the prison labor camps, 교화소. And there's been many different descriptions about crimes against humanity, political prison camps, ordinary prisons, religious believers, North-Korean escapees, starving populations, international abductions, enforced disappearances. And of course, if we are to reach a beyond reasonable doubt, it may be sufficient. It is a reasonable, sufficient possibility. So in a more relaxed rule of application, this is merely indicating it may be worth investigating. That is what the COI indicates. It's not conclusively saying that there is a violation, but violation may as well possibly occur. And ICC, refer to the situation to the ICC by the UN Security Council was also recommended on the R2P. There's been discourse about the failure of the R2P by the sovereign state, and therefore there's a manifest failure for the territorial state, and therefore the consideration of the transition justice question was raised. I'll be very brief with this, so let me skip this part. On the ICC, at the ICC, we have IMT going on right now for the ICC. Rome Statute does not include North Korea. It's not non-party states. So UN Security Council must approve for anything to be referred to the ICC. And China has been the member who has always objected to the application. Now we have Russia as well. Now we're looking at another possibility. Human rights infringement of North Korea was dealt at the COI. It has made an redundant the comment as well that genocide does not occur. I believe that when it comes to religious believers, it's a genocide as well as crimes against humanity. I think it could be possibly mentioned for the religious believers. And of course, proving genocide is very difficult. There should be genocide intent. Traditionally, it's difficult to prove the genocide intent. But there is the possibility of applying extermination. After murder, there is extermination. Murder is just killing. Extermination is an intention of mass killing. It's lesser of a harder compared to genocide. It may not have a genocidal intent, but extermination may also refer to massive killings. Now, to put it simply, there is a possibility of genocide as well. That's what I want to say. Proving it is going to be not impossible, but very difficult. So it may be better to focus on the crimes against humanity. Strategically, I think it's going to be not the wrong thing to do. We have the cases in Myanmar, we have cases in
여러 나라가 관련이 되는데 최근에
other countries where genocide was applied. ICJ is different from ICC.
자신과 관련 없는 행위라도 제소를 할 수가 있거든요. 강제관할권이 있어서 최근에
ICJ may exercise the jurisdiction, and therefore it has exercised the jurisdiction to Myanmar, Ukraine, and Israel, I think.
기본적으로 우리가 북한도 제노사이드 협정 당사국입니다.
And North Korea is also a part of signatory to the Genocide Convention. Now, this is something between the states, ICJ. But I think executive order, the provisionary the order may also be issued through it. It has lower hurdle. It is also another strategy that we might consider to apply. Let me wrap up because I think my time is up.
생길 수 있는 게
I think we need to look at the possibility, such possibilities in the future. In the war of Ukraine, North Korea has sent its troops. I can't remember was it Kirkus? Now the North Korean troops are deployed there. That's a former Russian territory. And now North Korea has entered the territory. The attack has been waged by Russia, and occupation may happen. Israeli and Palestine occupation. If you occupy a territory, you should withdraw someday. So Ukraine did not attack the Russian territory. Russia has attacked the Ukraine territory, but because of battles that took place afterwards, Ukraine has now entered the Russian territory. But it is originally the Russian territory. Looking at the jurisdiction issue from the ICC perspective, it's still a Russian territory. But over the border, Donbass and the Crimea is the Ukraine territory, internationally speaking. And if Ukraine territory has been attacked, then because the Ukraine has recognized the ICC application, Kim Jong-un has not done it together. But if there's like a aggression act, then there can be a violation of the ICC in the Ukraine territory. There has been a lot of talks about whether the North Korean troops have entered the Ukraine territory, but any criminal act committed by the North Korean army will be subject to the ICC. ICC will issue a warrant. I'm not sure if the North Korean army has entered already, because all the news that we're looking at right now come from Ukraine. So even if the North Korean army enters the Ukraine territory, we don't know if they have carried out the war crimes, but if they attack the civilian population, that will be a war crime. But I think it's still very important, because we're now looking at a whole new possibility.
그리고 아까 말씀드린 ICC
And then we have to go back to the ICC. It has to be anything that happened before the 2012, but for the continuous crime, there could be an exception. Other than that, and not 2002, excuse me, 2002. So anything that is happened before 2002, the establishment of the ICC, ICC does not have a jurisdiction. For the ad hoc the tribunals, in the future, when there is a change in North Korea, if there's a consensus or perhaps there's a collapse of North Korea, ad hoc tribunal is not a bad option, from my perspective. No, I'm sorry. Mixed tribunal is not a bad option. I make corrections here. I'm not saying that we should aspire to have a mixed tribunal, but mixed tribunal could be a good consideration for South Korea. And now, universal jurisdiction may be applied by domestic courts. Some countries made such attempts. This is not a simple issue, but we may consider it a third country exercising a universal jurisdiction to put into trial of the criminals in domestic courts. This brings me to the end of my presentations. I walked you through international law, international criminal law, and what kind of issues that we need to consider in looking at the tribunals. And I'm sure that there's been a lot of things discussed already at the IMT, but I wanted to help you, so I tried to bring you a bigger picture of the issues that have been discussed yesterday and today. Thank you very much. I don't think we have a Q&A session, but if you have any questions, please make your inquiries to the email that I had left with the organizers. Thank you very much.
네, 저는 장원재라고 합니다.
It's a great pleasure to meet you all. I am Chang Won-jae, and I've been running Bena TV for 11 years, since 2014, that works for North Korean defectors. And last March, I visited Killing Field of Cambodia, and I've opened a channel, a program that was to be the initial program for Bena TV. From April 1975 to 1979, there was a country massacre that took place, a staggering 1.7 to 3 million massacre of its own citizens. And the reason why I decided to visit this area was because it was a place quite similar to the political prison camps. In 1979, Pol Pot's regime did collapse, but still, amongst the Cambodians in their hearts and physically, there are the remnants of that massacre. UN took the lead to establish an extraordinary chambers in the courts of Cambodia, and from 2022, there was word on the trial, and in September of 2022, it has ended. So if you look at the trial in itself, it took about 11 years. But for the Cambodians, with regard to the actual ruling and the assessment and the deliberation, there was a huge gap. Only 3 was convicted, and 2 out of the 3 died in jail. And in addition to that, there were the accused with regard to genocide, and in the process of trial, they passed away. So for the Cambodians, what they of course wanted was to have them convicted, and they have waited more than 10 years, and there were some clear indications and clear evidence of the massacre, but it took so long. The procedures and the proceedings took so long, and it took them so much time to put them to justice. And around 280 million was actually consumed. So it was a highly costly trial. I've prepared a video, and this video is a 10-minute video, and I will provide my commentary in between, and then I will make sure to end before 12:30, so that would be my goal.
Sorry for not preparing English subtitles. 바로 시작하겠습니다. 첫 번째 영상입니다.
Yes, this is the very first video.
1975년 4월부터 1979년 1월까지 4년이 채 못 되는 시간에 무려
Interpretation of video materials is not provided.
캄보디아의 킬링필드입니다. 저희는 지금 그곳으로 날아갑니다. 가장 잔혹하고 악명 높은 감옥 뚜얼슬랭, 일명 S21은 수도인 프놈펜 시내 한 가운데에 있습니다. 2만여 명이 수감되어 단 12명만 살아남았다는 인류 역사상 가장 참혹한 시설입니다. 번화가 한 가운데에 이런 끔찍한 역사를 가지고 있는 장소가 있다는 것이 믿어지지 않습니다. 지금은 국립박물관입니다. 캄보디아에서는 앙코르와트와 더불어 역설적이지만 전 세계에서 가장 많은 관광객이 찾아오는 장소이기도 합니다. 사람들은 이 주변에서 음식을 팔고 관광객을 상대로 음료수를 팔며 삶을 영위해 갑니다. 이 사람들에게도 수십 년 전에 있었던 아픔은 과연 어떤 의미일까요? 정문이 보입니다. 예전에는 고등학교로 쓰였던 건물이라고 합니다. 이 담 안쪽으로 참혹한 현장이 그대로 보존되어 있습니다.
지금 제가 서 있는 곳이 뚜얼슬랭 추모박물관 담벼락입니다. 이 담 안쪽이 뚜얼슬랭, 그러니까 일명 S21로 불렸던 수용소입니다. 크메르루주는 1975년 4월 정권을 잡자마자 학교였던 이곳을 대규모의 감옥으로 개조했습니다. 그리고 약 2만 명에 달하는 사람들을 잔혹하게 고문했습니다. 이곳은 감옥소로 개조하기 전까지는 고등학교였다고 하는데요. 폴포트가 이곳에서 근무했었다는 얘기도 있습니다. 그 점은 제가 나중에 한번 확인을 해보겠습니다. 입구를 지나면 한때는 학교였다가 나중엔 감옥으로 쓰였던 A동, B동, C동, D동 4개의 건물을 보실 수 있습니다. A동과 B동 사이에는 14기의 무덤이 있습니다. 무덤의 임자가 누군지는 모릅니다. 1979년 1월 10일 베트남군이 크메르루주를 무너뜨리고 프놈펜에 입성했습니다. 모든 문명의 이기는 인민의 적이라고 생각하던 크메르루주였으니까 아마 자기들끼리 통신도 변변하게 이루어지지 않은 것 같습니다. 그래서 그들은 서둘러서 도망쳤습니다. 문서를 태우지도 못했고 고문 도구를 증거인멸하지도 못했습니다. 1월 10일 한 베트남의 종군 기자가 이곳에 들어와서 사진을 찍었습니다. 고문실에는 철제 침대 위에 족쇄에 발목이 묶인 채로 피칠갑을 하고 시신이 된 14구의 시체가 있었습니다. 시체 위에 의자가 놓여 있는 경우도 있어서 사람들은 아마 이곳 교도관이 그 의자에 앉아서 마지막 순간까지 이곳 수감자들을 고문한 흔적이 아닌가 그렇게 추측합니다. 이 사진을 찍을 때 종군 기자였던 베트남의 호반 타이 씨가 어떤 심정이었을지 잘 모르겠습니다. 너무나 끔찍한 광경이었겠지만 그래도 기록을 남겨야 한다는 의무감에서 촬영을 했을 것입니다. 한 종군 기자 덕분에 이곳 S-21 비밀 수용소의 끔찍한 참상이 외부로 전 세계로 생생하게 알려질 수 있었습니다. 이곳은 들어갈 수는 있지만 나올 수는 없는 곳, 이렇게 불렸습니다. 2만 명 정도가 수감되었지만 생존자는 단 12명, 7명의 성인과 5명의 어린아이가 전부입니다. 크메르 루주는 한 사람의 적을 놓치는 것보다는 무고한 사람을 얼마든지 죽이는 편이 더 낫다라고 생각했던 집단입니다. 잡초를 뽑으려면 뿌리까지 뽑아라, 이런 말을 남기고 자기들에게 반대하는 사람들은 갓난아기까지 잡아다 모두 살해한 잔혹무도한 집단입니다. 이곳에서 살해당한 사람들의 가족 중에는 신원이 알려지지 않은 14구의 시신을 오히려 부러워하는, 웃지 못할 경우도 있습니다. 그 사람들이 보기에 그래도 이름 없는 시신들은 누군가가 시신을 수습해서 정중하게 매장을 해주고 적어도 어디에 묻혔다는 건 알 수 있기 때문입니다. 지금 제가 담벼락에 서 있습니다만 이것도 그 당시에 어떤 용도로 쓰였는지는 모르겠습니다. 기록에 의하면 고문을 하다 죽어나간 사람들을 수용소가 어딘가에다 구덩이를 파고 모두 묻었다라고 했으니까요. 죽어나가는 사람들의 숫자가 많아지자 이곳 교도소장과 교도관들은 전염병을 걱정했습니다. 수감자들 사이에 전염병이 퍼질까봐 걱정한 것이 아니죠. 자기들이 시체가 썩는 곳에서 발생한 전염병으로부터 감염당하는 것을 두려워한 겁니다. 그래서 어느 순간부터 그들은 처형해야 될 사람들을 트럭에 실어서 이곳으로부터 남동쪽 11km쯤 떨어진 킬링필드로 보냈습니다. 킬링필드에는 지금 5천여 구의 유골이 위령탑 안에 봉헌되어 있습니다. 그리고 이곳에서 얼마나 더 많은 사람들이 죽어나갔는지는 알 수 없습니다. 어쩌면 이곳은 인간성의 바닥, 인간이라는 존재가 어디까지 얼마나 잔인해지고 참혹해질 수 있는지를 보여주는 살아있는 교실인지도 모르겠습니다. 그런데 투얼슬랭을 한 바퀴 돌아보면서 다른 감정이 올라옵니다. 수많은 탈북자의 증언에 의하면 이곳 투얼슬랭 감옥보다 요독 수용소, 그리고 북한에 있다는 수많은 정치범 수용소, 이곳 투얼슬랭보다 훨씬 더 열악하다고 합니다. 이곳에서 느끼는 참혹함도 이 정도인데 과연 북한에서는 지금 어떤 일이 벌어지고 있는 것일까요? 이곳 투얼슬랭의 참상은 적어도 1979년 1월 10일 이후로는 일어나지 않았습니다. 북한에서는 지금 이 시간에도 실시간으로 수많은 인권 유린이 자행되고 있습니다. 그래서 제 마음은 이곳에서 훨씬 더 무겁습니다. 투얼슬랭 정문입니다. 매표소가 보입니다. 별도의 비용을 내면 해설용 이어폰도 빌려줍니다. 한국어판도 있습니다. 내부로 들어왔습니다. 14명의 묘지가 보이네요. 고문대 위에 방치되어 있던 시신들입니다.
왼쪽으로 보이는 건물이 A동입니다. 감옥 그리고 고문실로 쓰였습니다. 오른쪽에 보이는 판은 규칙을 적어놓은 판인데요. 묻는 말에만 대답하라, 규칙을 어기면 전기 고문 5회, 채찍질 5회 등이 아주 빼곡하게 써 있습니다. A동 끝으로 생존자들의 사진이 보입니다. 베트남군이 시설을 장악했을 때 단 7명의 생존자가 있었습니다. 이들은 모두 기술자여서 살아남았습니다. 조서 작성용 타이프라이터 수리공, 족쇄 제작 기술자, 폴포트의 초상화를 그릴 수 있었던 화가 등입니다. 이들 중 몇 분은 책을 써서 자신의 참담했던 기억을 후세에 전합니다. 전 세계 모두 관광객은 마찬가지입니다. 이곳에서는 숙연한 표정을 짓고 숙연한 마음으로 시설을 둘러보게 됩니다. 오른쪽 안쪽으로 철창들이 보이죠. 이 안에가 신문실 그리고 고문실이었습니다. 내부로 함께 들어가 보시죠. 네, 학살의 주범 폴포트는
So Pol Pot is not his real name. It actually comes from political potential. And I've mentioned that 1.7 to 3 million people died, but this is just an assumption. 1.7 million is just the bare minimum. And then for those that have died out of forced labor and starvation, we believe that it's close to 3 million. So that's the report that we've got from on the field. So Cambodia has been exporting food, and they can actually engage in rice harvest 3 times per year. However, ever since the communist rule, there were so many people that have died, as you saw in the video. And let us now move on to the second video.
전 세계 모두 관광객은 마찬가지입니다. 이곳에서는 숙연한 표정을 짓고 숙연한 마음으로 시설을 둘러보게 됩니다. 오른쪽 안쪽으로 철창들이 보이죠. 이 안에가 신문실 그리고 고문실이었습니다. 내부로 함께 들어가 보시죠. 실내로 들어왔습니다. A동 1층은 전체가 고문실입니다. 여러 개의 방이 있습니다. 과거에는 모두 교실이었던 곳이죠. 수감자들은 철제 침대에 묶여 고문을 받았습니다. 족쇄에 발이 묶이고 온몸이 철제 침대에 결박이 됐습니다. 갈색통은 변기통입니다. 지금은 사라졌지만 얼마 전까지만 해도 이곳 고문실 바닥엔 핏자국이 흥건했었다고 합니다. 모든 방의 벽면에는 1979년 1월 10일 뚜얼슬랭을 베트남군이 막 들어왔을 때 당시에 사진이 걸려 있습니다. 참혹했던 시신들의 사진을 그대로 담고 있습니다. 저 족쇄에 묶였던 사람은 누구였을까요? 바로 앞마당에 묻힌 이름 없는 14구의 시신들입니다. 피칠갑을 하고 누워있는 시신들의 사진은 다시 볼 수 없을 만치 끔찍합니다. 도대체 인간은 어디까지 잔혹해질 수 있는 것일까요? 족쇄에 발이 묶이고 허리는 철제 침대에 벨트로 고정이 되었습니다. 그리고 이런 모습으로 죽어나갈 때까지 고문을 받았습니다. 이곳에 와서 구토를 하거나 차마 이 방을 다시 보지 못하는 관람객들도 있었습니다. 쓰러진 의자가 있습니다. 아마 저 시신이 죽기 직전까지 누군가가 고문을 했던 흔적일 겁니다. 그들에게 이곳에 끌려온 사람들은 인간이 아니었습니다. 얼마나 많은 물리적 타격이 가해졌으면 철제 침대가 저렇게 휘어져 버린 것일까요? 모든 방마다 얼마나 많은 사람들이 와서 얼마나 끔찍한 고문을 당했던 것일까요? 지금 제 뒤로 멀리 보이는 곳이 수용소 A동, 그리고 가까이 보이는 곳이 수용소 B동입니다. 이곳에 수감되었던 수감자들은 이름이 없었습니다. 정확히 말하면 이름이 있었죠. 그런데 그 이름은 이곳에 들어온 뒤 딱 3번만 쓸 수 있었습니다. 첫 번째는 끌려온 직후 인적 사항을 조사할 때였습니다. 두 번째는 고문에 못 이겨 허위 자백을 하고 강요에 의한 자백이 맞다고 시인할 때, 그때 이름을 썼습니다. 세 번째는 이곳에서 사형장으로 떠나는 버스에 올라탈 때 사형 집행에 동의한다는 문서에 자기의 이름을 썼습니다. 크메르 루주는 잡초를 뽑을 때는 뿌리까지 뽑아야 한다, 이런 슬로건을 가지고 가족 전체를 말살했습니다. 1살, 3살, 5살 수많은 어린이들이 역시 이곳에서 숨져갔습니다. A동 2층으로 올라가는 계단입니다. 누군가에겐 죽기보다 힘든 길이었을 겁니다. 고문당한 몸으로 간수를 무등 태우고 2층, 때로는 3층까지 올라가야 했으니까요. 복도를 돌면 예전 고문실을 개조한 전시실이 있습니다. 이 방은 이곳 뚜월 슬랭에서 참혹하게 살해된 어린이들의 유품을 모아놓은 곳입니다. 부모와 함께 끌려온 어린이들도 반동분자라는 이유로 모두 살해당했습니다. 크기를 보면 저 옷을 입었던 여자아이는 4살, 5살, 6살, 그 이상은 아니었을 것 같습니다. 아직도 옷에 선명하게 남아있는 핏자국이 보는 사람들의 가슴을 미어지게 만듭니다. 오른쪽 바지는 다른 소년이 입었던 옷이라고 합니다. 그리고 1살, 2살, 3살 영유아들이 입었던 옷들도 이렇게 전시되어 있습니다. 물론 이 어린이들도 모두 죽었습니다. 부모와 함께 끌려왔던 어린이들의 사진이 있습니다. 어른들처럼 목에 죄수 번호를 달고 사진을 찍었습니다. 이 소년의 목에 감겨있는 쇠사슬이 당시의 상황, 모든 상황을 말해줍니다. 희생자들의 넋을 생각하는데 달은 화창하고 바람은 온화해서 더 서럽습니다. 그들은 적 한 명을 놓치는 것보다는 무고한 시민을 죽이는 것이 더 이익이다 라는 식으로 행동했습니다. 그래서 여기에 끌려온 수많은 사람들은 자기의 죄목이 뭔지도, 무엇 때문에 끌려왔는지도, 누가 자기를 밀고 했는지도 모르는 채 끌려왔습니다. 그리고 크메르 루주가 강요한 그들이 만든 시나리오에 따라 자백을 할 때까지 무수한 고문을 당했습니다. 이곳에 끌려온 사람들에게는 이름이 없었다. 그리고
단 3번만 이름을 사용할 수 있었다라고 말씀드렸지만 아이러니컬하게도 그들의 이름을 정확하게 적은 문서가 발견됐습니다. 크메르 루즈는 기록에 집착했습니다. 이곳에 끌고 온 사람들의 나이, 성별, 주소, 직업, 가족관계 등을 꼼꼼하게 기록한 문서를 남겼습니다. 그들은 도망가면서 고문 도구들을 증거인멸하지 못했고 문서들을 소각하지도 못했습니다. 그만큼 쫓기듯 달아났으니까요. 덕분에 이곳에 수감되어 있던 사람들의 신문 조서도 온전하게 살아남았습니다. 나중에 유엔에서 크메르 루즈를 전 세계 인권의 이름으로 단죄하는 법정이 열렸을 때 그 문서들은 증거로 채택되었습니다. 크메르 루즈는 왜 그렇게까지 기록에 집착했던 것일까요? 어쩌면 자기들이 하고 있는 것이 허황된 것이다. 자기들이 하고 있는 이 거대한 거짓, 말도 안 되는 미친 짓거리가 문서를 통해서 기록으로 남으면 증거가 된다고 생각했기 때문일까요? 문서에 신문 기록을 꼼꼼히 담아 놓으면 그 거짓 주장들이 사실일 수도 있겠다. 그런 그릇된 믿음을 가졌던 것은 아닐까요? 공산당은 기록에 집착합니다. 김씨 정권이 무너지고 평양에 있다는 문서 기록 보존소에 어떤 문서들이 있는지 제 두 눈으로 꼭 확인하고 싶습니다. 네, 평양에 있다는 문서
So in Pyongyang, there's supposed to be a written records archive, and I do know that the U.S. And certain governments understand where the location, and what you see on the floor are all remnants of blood. And they do say that compared to 10 years back, it's not as dark, but you can still see the scars, the traces of blood. And if you also go to these individual rooms, when the Vietnamese military have actually went into these buildings, there are specific pictures, but I've blurred them all because they're just so horrendous. And it seems as if it's just pieces of meat, basically, which were supposed to be human beings, all shackled to these steel beds. So I don't know how to put it, but it just seemed like pieces of meat scattered across. And the next image or the next video is a testimony by a survival. There were 12 out of 20,000 that have survived. 7 are adults and 5 are children in terms of the survivors. And one child, after rescued, was an infant but died immediately. So in terms of the number of survivors, there could be +1 or ±1, but next is a testimony of a child, a survivor.
그 중에 한 아기는 구조 후 5일 만에 사망했습니다. 생존자 중에 한 사람인 노룽 참팔 씨를 만났습니다.
Hello, nice to meet you, gentlemen. I am Dong Chanpal. I'm child survivor in this prison. The teacher told us boy that me. 1979, I was 9 years old. My younger brother was 6 years old. Yeah, all together 5 child and 3 ladies with my mother. The Khmer who arrested from Kampong province, 75 kilometers from here. How we could survive because they are Vietnamese army. Come join with the Cambodian Liberation Army fighting the city. The Khmer who start move like prisoner get out to kill. I heard like that. Then I heard my mother told me. Well, the Khmer separated me from my mother. Son, take care of your brother. What happened when run away from him? Look after him, son. My mother told me like that and she cried. What time I took the baby and me together. We are hiding in a big pile of clothes, waiting for my mother to come back and took me home. But she doesn't come back. The Khmer killed my mother and father. Two baby, they are lucky than me. They were adopted to the Germany. Now no information. And one baby from an old died, don't have no money. Only 4 still alive. Yeah.
What's the most difficult point in the prison?
very difficult. They touch my mother and that room. Yeah, put her hair like that. And down, fall on table. My mother gets blood out from her nose. I saw like that. I'm hold my mother and cry, and her blood and drop my shoulder, drop my hair. Yeah, after that it took me then and then and asked my mother that who is me. He took me to building C, top floor second room. Yeah, one night she doesn't sleep at all. Care me, she don't with me. I tried to ask mother why they touch your mother and what did you play? He come back home, mother. I told my mother like that. She not answer to me. Just put her head like that. No son, no daughter. Try to speak, try to speak. And next morning they separated me from my mother and took me at the campus.
How can you get back normal life? How can you make it?
Yeah, after that, the Vietnamese army, they come here, they found me, they brought me out to the hospital. After that, they took me in outreach center in Cambodia. Near here, outreach center, near here, 45 kilometers from here.
What do you think about Khmer Rouge?
Yeah, the Khmer Rouge is communication idea, very bad. From this communication idea, communication from Mao Zedong, China, Mao Zedong, and they are build a new society, no money, and no rich man, no poor man, live all together. Not have poor man, rich man, just citizen. Do, can eat, not do, not eat.
Do you have any relationship with other survivors?
For children survive, but now only me and my younger brother. But my younger brother not come back here. He's scared about this place.
So, because of scaring, so your brother cannot come. Cannot come. Anyway, is he still alive?
Still right now.
How old are you and your brother?
I'm now 53, and my younger brother now 50.
Your brother cannot come here.
Cannot come.
Okay. Do you have any messages to the younger generation of Cambodia and younger generation of the world?
I said, I talk a lot of the people to the young generation around my country, public school and private school. Yeah, my experience here, I told them that don't have the Khmer Rouge again. Because now, the people around the world, they knew about the Cambodia. Not citizen, just have the peace, no war. And love my country, love your country, all together. Friendship.
Did you have any testimony to the ICC court?
Yeah. I come join the court. The court, ICC. Yeah. 2009, that me. I went to the court for testify for justice my mother and father. I met with the head of this prison. When I met him the first time, that man rejected me. He doesn't believe me at all about child by this prison. Because this court very late, so late. 1979, this preacher, that court 2009, he doesn't believe me. After that, I tried to found my mother and father biography in the prison. The letter wrote by hand and PRC code, he called my father. My father named Nong Chen, 46 years old. He worked with the machine cut wood, built a railway in Postby, Province. The dad arrested him 22 December 1978.
When you showed this document to him, what did he say?
Yeah, after they saw that document, they accept me, recognized and said, apologize to me, and told me my family, the last victim, they arrested prison. If you not found that document, he doesn't believe me. Yeah, they took a hand like that. Please all the victims, keep the door open, no close the door. He tried to say apologize, all victims killed by himself. He passed away 2020.
Can you accept his approach?
They said like that, they knew about it. He said, and then after that, he died. Now, everything the past, I keep my hand, I cannot put my heart. I keep out. now they pass away. I hope so. I have justice, but not 100%, but I can get one small part.
Okay, thank you for
Thank you so much
accepting
for
my request. Aku.
Akun.
노룽 참팔씨는 1979년 1월 10일 이곳 뚜얼슬랭 감옥을 접수한 베트남군에 의해서 구조되었습니다. 시체들이 남긴 옷더미 속에 다른 어린이들과 숨어 있다가 극적으로 살아난 것이죠. 이 감옥에 오기 전 노룽 참팔씨는 어떤 인생을 살고 있었을까요? 크메르 루주는 모든 도시 거주자 그리고 분홍들을 농촌으로 하방했습니다. 그들은 캄보디아에서는 부자가 가난한 사람을, 인텔리가 교육 못 받은 사람들을, 그리고 도시 거주자가 시골 농민을 수탈하고 있다고 했습니다. 그래서 모든 사람들을 농촌에 몰아넣고 계급도 부자도 가난한 자도 없는 원시 농촌 이상 마을을 만들겠다고 공언했습니다. 그들은 육체 노동을 안 하는 사람은 다른 사람의 피를 빨아먹는 흡혈귀라고 했습니다. 그리고 모든 논으로부터 3배 이상의 수확을 올려야 한다고 했죠. 농기구 파손, 감자, 쌀 등을 훔친 사람, 자기 농사를 지은 사람은 모두 사형시켰습니다. 크메르 루주는 가족을 파괴했습니다. 모두가 집단 생활을 해야 했습니다. 부모와 아이들을 분리했습니다. 아이들은 이렇게 아이들만으로 이루어진 공동체에서 생활해야 했습니다. 부모를 만나는 것은 엄격하게 금지되었습니다. 이 사진은 크메르 루주 고위 공직자의 사진입니다. 아주 예외적인 경우죠. 결혼은 당이 정해준 사람과 해야 했습니다. 군인이 지명을 하면 어떤 여자든지 이를 거부할 수가 없었습니다. 결혼은 가정을 만드는 것이 목적이 아니라 생산의 기반이 되는 어린이를 낳는 용도로 쓰였습니다. 1979년 1월 6일 베트남군이 이곳 프놈펜을 접수했습니다. 뒤늦게 소식을 들은 뚜얼슬랭의 간수들은 1월 8일 모두 도망갔습니다. 이곳에 남아있던 어린이들은 이틀 동안 빈 감옥에서 살아남았습니다. 모기가 알을 낳은 물을 마셨습니다. 그들이 유일하게 구할 수 있었던 물입니다. 그리고 모두 닷새 동안 설사를 했죠. 노룽 참팔씨는 어머니를 찾아 이 방 저 방을 뒤지고 다녔습니다. 절제 침대에 묶인 시체도 봤고 그 시체들이 뿜어내는 부패한 냄새를 지금도 잊지 못합니다. 베트남군이 준 누룽지 맛도 잊지 못하고 있습니다. 크메르 루주는 뚜얼슬랭으로 잡혀온 모든 사람들의 신상 정보를 일일이 기록으로 남겼습니다. 급하게 도망가느라 이 서류들을 소각하거나 폐기하지 못했습니다. 그래서 우리는 어떤 사람들이 잡혀와서 어떻게 죽었는지를 알 수 있습니다. 노룽 참팔의 아버지 노룽첸의 서류입니다. 직업 목수, 1932년생, 1978년 이곳 S21에서 사망. 노룽 참팔의 어머니 요부는 1928년생입니다. 이곳에 1979년 1월에 끌려와 S21에서 사망했습니다. 직업은 농부, 주부, 그리고 가축 기르기가 특기였다고 기록이 되어 있습니다. 어머니의 유일한 유품, 숟가락입니다. 크메르 루주가 허용한 유일한 사유재산이기도 합니다. 어머니는 이 숟가락을 집단 농장 시절부터 사용했습니다. 어머니의 흔적이 그립습니다. 감옥에서 나온 8년 후 1987년에 찍은 사진입니다. 왼쪽이 노룽 참팔씨입니다. 어머니가 맞는 것을 보고 울음을 터뜨리자 간수가 이렇게 말했다고 합니다. 뚝 그쳐. 그런 그렇지 않으면 네 애미처럼 패버릴 테니까. 그 점은 성인이 된 지금도 트라우마로 남았습니다. 그래도 결혼을 해서 이렇게 가족을 이뤘습니다. 감옥 시절을 생각하면 그야말로 꿈만 같은 일입니다. 1986년 헝가리는 캄보디아 고아들을 위해 고아원을 세웠습니다. 헝가리 방문단을 환영하기 위한 고아들입니다. 노릉참팔 씨도 고아원에서 한동안 생활을 했습니다. 1995년 결혼식 사진입니다. 아내는 노릉참팔의 과거를 따뜻하게 안아준 사람입니다. UN 특별재판소에서 증언을 하고 있는 청년 노릉참팔입니다. 왼쪽 사진은 당시 뚜월 슬랭의 책임자였던 끽아오입니다. 노릉참팔의 가족 사진입니다. 노릉참팔은 7남매 중 6번째였습니다. 노릉참팔은 왜 자기가 크메르루주를 절대로 용서할 수 없는지에 대해서 이렇게 얘기합니다. 그들은 사랑과 우애를 저버렸습니다. 왜? 크메르루주만이 사랑과 존경을 받을 수 있는 유일한 대상이라고 생각했기 때문이죠. 크메르루주는 누구를 사랑할지, 누구와 결혼할지, 무엇을 할지, 무엇을 먹고 배울지를 일일이 간섭하고 통제했습니다. 그들은 인간성을 철저히 깨부순 만행을 저지른 집단입니다. 그래서 저는 도저히 용서할 수 없습니다. 이런 점을 보면 지금 현재 북한의
So if you see what happened in the video and what's happening in North Korea, you can, well, for me, it's a comparison. But will Kim Jong-un really apologize? Will we say sorry? But even if he does apologize, will that mend or heal the families? Tuol Sleng is noted as the S21 prison. S stands for secret 21. So, in this video, you've seen the survivor, a child, and the guard said if you cry when you see your mom being beaten, you would also be beaten as well. So that was what that guard said. And I also have a video of the guards of the prison, S21.
하는 유명한 사진 중에 하나입니다. 아이를 안고 찍은 젊은 엄마. 이 여성도 며칠 후에 잔혹하게 살해당한 것으로 알려져 있습니다. 뭔가 생사를 초탈한 듯한 초연한 표정이 압권인데요. 이 여성은 끌려오자마자 어떻게 이런 표정을 지을 수 있었던 걸까요? 이곳에서 어떤 일이 일어나는지 혹시 알고 있었던 것은 아닐까요? 이 여성의 남편은 크메르루주였습니다. 크메르루주의 초급 공산당 간부였습니다. 남편의 이름은 섹사스라는 기록이 있습니다. 어쩌면 모든 것들을 어렴풋하게라도 남편으로부터 들었는지도 모르겠습니다. 크메르루주는 우리 편, 내 편을 가리지 않았습니다. 이곳 교도관들은 악명 높기로 유명했죠. 고문을 할 때는 상대와 감정이입을 하지 못하도록 교육받았습니다. 원하는 답이 나올 때까지 그들을 인간으로 취급하지 않고 찌르고, 베고, 채찍으로 때리고 물고문을 가했습니다. 원하는 답을 좀 더 빨리 얻어내고자 물고문의 방식도 바꿨습니다. 그냥 물이 아니라 인분이 섞인 하수도물을 길어다가 그곳의 수감자들의 머리를 쳐박았습니다. 물고문이 자행되었던 바로 그 현장입니다. A동과 B동 사이에 위치합니다. 고등학교였을 때 이곳은 철봉으로 쓰였다고 합니다. 감옥이 된 뒤로 용도가 바뀐 것이죠. 수감자들의 목을 매달지는 않았습니다. 여기는 철저하게 고문의 현장으로만 이용을 했습니다. 사람의 팔을 묶어 철봉에 매달아 놓는 일명 비둘기 고문, 그리고
몸을 묶은 사람들의 몸을 늘어뜨려 저 아래 물통 속에 머리를 처박게 하는 그런 고문이 자행됐던 곳입니다. 이곳 수감자들은 밖을 볼 수 없었습니다. 그러나 고문을 받으러 혹은 기타 다른 이유로 이동을 하면서 이곳에서 물고문을 받고 고통스러워하는 사람들의 모습을 보았습니다. 이 석고상은 그 사람들의 증언을 모아 당시의 기록대로 재현한 것입니다.
좁은 독방에서 제대로 청소를 하지 않았다고, 그러니까 배변통을 제대로 비우지 않았다고 그것을 모두 핥아 먹도록 했습니다. 어떻게 그런 비인간적인 행동이 가능했던 것일까요? 폴포트는 자기가 수족처럼 부리기 위한 사람들을 시골에서 찾았습니다. 12살부터 20대 초반까지의 어린 친구들입니다. 이들에게는 폴포트에 대한 맹목적 충성심을 강요하고 슬로건 몇 개를 외우게 한 뒤 바로 이곳으로 배치했습니다. 그래서 그들은 더할 나위 없이 잔혹해질 수 있었습니다. 문제는 그들 가운데 상당수가 나중에는 반역자로 몰려서 이곳에 수감되었고 그들이 고문했던 사람들이 받았던 똑같은 고통을 그대로 당했다는 겁니다. 비인간적인 고문을 받으면서 그 소년병들은 무슨 생각을 했을까요?
뚜얼슬랭 박물관 한쪽 벽에는 소년병들의 사진이 왜곡합니다. 모두들 베레모를 쓰고 있습니다. 저 베레모야말로 간수들의 상징입니다. 수감자들은 모자를 쓸 수 없었습니다. 대부분의 어린아이들은 문맹입니다. 맹목적으로 크메르 루즈를 추앙했던 배경입니다. 한쪽에는 사람 뼈가 가득합니다. 온전한 뼈가 없어서 더 가슴이 시립니다. 한두 개의 뼈는 공포스럽지만 이렇게 수많은 해골들이 모여 있으니 무섭다기보다는 기괴하다는 생각이 듭니다. 인간의 참혹함에 몸을 떨게 됩니다. 모든 해골에는 물리적으로 구타를 당한 흔적이 남아 있습니다. 공산당의 속성을 잘 보여주는 증거품입니다.
폴포트는 모든 지식인을 혐오했습니다. 의사, 교사, 변호사, 나중에는 안경을 쓴 사람, 심지어는 글자를 읽을 줄 아는 사람까지 모두 이곳 수용소로 데려왔습니다. 이곳 벽면에는 글자를 알지 못해서 숫자를 쓸 수 없어서 바닥에 홈으로 긁어놓아 표시를 한 이곳 교도관들의 흔적이 남아 있습니다.
숫자를 모르는 간수들이 벽면에 파놓은 홈입니다. 나중에는 자기들도 숫자를 배워 이렇게 벽에 숫자를 썼습니다. 문맹이 얼마나 불편한 것인지를 자기들도 깨달았다는 얘기겠죠.
그런 사람들조차 나중에는 이곳에 수감되어 모두 죽어갔다는 사실, 공산당의 잔혹함을 이보다 더 잘 설명하는 사례는 없을 것 같습니다. 사적인 복수를 하지 말라. 이것이 근대와 고대를 나누는 법률이라는 얘기를 하는 분들이 있습니다. 근대 문명사회일수록 사적 구제를 하지 말라는 얘기죠. 그렇지만 저는 이곳 수용소를 둘러보면서 복수심이 일어나는 사진 한 장을 발견했습니다. 호인 뚜엔이라는 남자의 사진입니다. 발목에 쇠고락을 차고 있습니다. 뭔가 어이없어 하는 표정, 체념한 표정, 약간의 공포를 머금은 표정, 설마 나에게 무슨 일이 벌어질까? 당혹해하는 표정들이 얽혀 있습니다. 이 사람은 누구일까요? 크메르 루즈의 핵심이었습니다. 상공부 장관이었죠. 아마 이 남자는 이곳에서 어떤 일이 벌어졌는지를 어렴풋이 알고 있었을 겁니다. 결론부터 말씀드리자면 이 자는 1977년 사형당했습니다. 크메르 루즈는 모든 지식인들을 박멸하고자 했죠. 아이러니컬한 것은 자신들 역시 지식인의 범주에 들어가는 사람이었다는 점입니다. 폴 포트는 프랑스에 유학까지 했던 교사 출신이었고 강요들 역시 교육을 받은 사람이었습니다. 일반 국민은 안경을 썼다는 이유로 살해했지만 저렇게 버젓이 안경을 쓰고 다녔습니다. 인민들을 순수하게 만든다, 혁명을 한다, 온갖 대의로 치장해 300만의 인명을 무참하게 학살한 폴포트 일당. 그 가운데 하나가 300만 중에 하나가 되어 저렇게 죽어갔다는 사실. 여러분들은 어떻게 생각하십니까? 공산주의는 결론적으로 사람을 사람으로 보지 않습니다. 도구나 물건으로 봅니다. 그래서 이런 잔혹한 일들을 계속할 수 있었던 것은 아닌가. 자기 편도 사람으로 보지 않았던 것 같습니다.
이곳에 끌려온 모든 수감자들은 저렇게 머그샷을 찍었습니다. 목 뒤로 보이는 것은 얼굴을 고정하는 장치입니다. 이 사진은 화가 반나스 씨 본인의 사진입니다. 폴포트의 초상화를 그린 덕분에 살아남은 화가죠. 수감자들이 야간에 이동하고 있습니다. 목에 줄을 꿰고 있습니다. 북한이 탈북자들을 운송하는 방식이죠. 목욕 장면입니다. 어쩌다 한 번씩 호수에서 저렇게 물을 뿌려줬다고 합니다. 만나스 씨는 수감자들의 명예를 위해 사실을 왜곡했다고 했습니다. 원래는 모두 나체였다는 것이죠. 평소에 모든 사람들은 저렇게 족쇄에 발이 묶여 있었습니다. 누군가가 굶어서 혹은 고통에 쓰러져도 돌볼 수가 없었죠. 족쇄는 쇠사슬을 이어 붙인 것이었습니다. 그러나 조금 더 고문을 해야 하는 특별한 죄수들은 저렇게 나무로 만든 큰 칼에 발목을 서로 집어넣게 했습니다. 한 사람의 움직임은 모든 이의 고통을 뜻했습니다. 독방 그림입니다. 한 사람이 겨우 누울 만한 곳이었죠. 그곳에서도 여전히 족쇄를 차고 있었습니다. 왼쪽에 보이는 것이 변기통입니다. 손톱빼기 고문입니다. 이곳의 특징은 모든 수감자들을 항거 불능 상태로 만든 뒤 철저하게 고문을 하는 것이었습니다. 여전히 발은 족쇄로 묶어놨고 팔도 책상에 쇠사슬로 엮어 놓았습니다. 어떻게 하면 고통을 극대화할 수 있을 것인가를 그들은 연구하고 또 연구했습니다. 고개를 돌리고 고개를 젖혀도 여전히 물은 코 속으로, 입 속으로, 그리고 폐까지 스며들었을 것입니다. 일반 물이 아니라 오염수를 써서 죄수들의 고통을 극대화했습니다. 굴비 두름처럼 엮인 것은 사람입니다. 교실 한 칸에 저렇게 많은 사람을 촘촘하게 눕혀놓았습니다. 칼처럼 누워있을 수밖에 없었던 이유가 있습니다. 발목에는 한 줄로 쭉 이어진 쇠고랑이 모두에게 채워져 있었으니까요. 또 다른 형태의 물고문입니다. 일단 상처를 내고 그 위에 수건을 덮은 뒤에 소금물을 들이붓습니다. 너무나 고통스러워서 입도 뻥끗 못합니다. 얼굴을 덮은 천이 말라오면서 목을, 얼굴을 조이는 고통도 또 다른 아픔입니다. 크메르 루즈는 가족을 파괴했죠. 그리고 반역자는 3대를 죽이라고 했습니다. 부모에게서 아이를 빼앗아 눈앞에서 난도질을 했다는 기록도 있습니다. 벽에 패대기쳐 죽인 아이들은 한두 명이 아닙니다. 북의 요독 수용소도 그렇다고 들었습니다. 특별히 고안한 익사체험 고문 도구입니다. 양팔을 양쪽 널빤지에 묶고 숨이 끊어질 때까지, 아니 끊어지기 직전까지 저는 이곳 뚜얼 슬랭이 인간성의 바닥을 보여주는 곳이라고 생각합니다. 인간이 어디까지 잔혹해질 수 있는지를 보여주는 살아있는 표본이라고 생각합니다. 그런데 북한의 정치범 수용소를 탈출해 우여곡절 끝에 대한민국에 온 탈북민들은 다른 얘기를 합니다. 북한 수용소의 실상이 이곳보다 더하면 더했지 덜하지 않다고 하는 겁니다. 공산당은 도대체 어디까지 잔혹해질 수 있는 걸까요? 이곳 뚜얼 슬랭보다 더한 곳이 있다면 우리는 지금 무엇을 해야 하는 것일까요? 인간성의 바닥을 보여주는 공산당의 만행이 북한에서는, 온 북녘 땅에서는 지금 이 순간에도 실시간으로 자행되고 있습니다. 다음 영상은
The next video is the testimony and an interview of an adult survivor.
트랜슬랭에 와서 생존자 한 분과 인터뷰를 진행하도록 하겠습니다. What's the most difficult thing in the prison at the time?
Mình tên là đừng sẽ bay về ở thấp tất cả bò đi, ở bên qua bị cô đi. Bây giờ clean về cái chặt ở những chọ cả lá cả đau chặt thì của mọi phụ việc khơi về bay giờ anh ấy bị ai chịu nôm đẹp quá đấy, anh ấy bắt trường thông, bắt trường thông. Bây giờ thưa ở trái bả lát về ai dương lật được vậy.
So this picture shows that he testimony
Yes.
at the ICC.
The International Court ICC, Extraordinary Chamber Court of Cambodia, invite him testimony.
What do you think about the ICC?
Là cả mai của ông vì mình ban mà rồi thì rồi đi, việc ban chất rất bát thật thì rồi đây. Của miền bờ tây châu Rome, miền bờ tây châu Rome.
He said,
What's the most difficult point after release the prison? Is it easy to get back to the ordinary life?
No. Yeah.
yes, this picture him. He almost died in the prison. During time he survived because he have skill mechanic. And second time during 1979 the Army's Cambodia liberation and Vietnamese soldier came here. Just get him outside. He survived. He survived on 7 January 1979. He survived.
If he, just in case, if he meet Pol Pot, what does he want to say to him?
He never met Pol Pot because of the Pol Pot escaped. He hid in the jungle, Pol Pot. But he met Mr. Dudley, the S-21, in the court. With Mr. Dudley.
What was his feeling when he met Mr.
Dudley.
Yes, the boss of the S-21.
Nhưng trong vay biết bên đây dân ăn thêm vay đây là tập thể nhân bạc. Nhưng ăn thêm vay biết thì tụi ai bạc cái đó khôngត្រូវai.
Okay. The last question. Any messages to the young generation of the world?
សូមឲ្យគាត់យកអានឹងទៅដើម្បីជួយផ្សព្វផ្សាយឲ្យពិភពលោកបានដឹងការពិតថាខ្មែរសម្រាប់ខ្មែរអស់ជិត3លាននាក់យ៉ា
Okay, thank you. Akun.
뚜얼 슬랭 시동의 모습입니다. 1층부터 맨 위층까지 촘촘하게 철조망이 쳐 있습니다. 원래는 A동, B동, C동, D동 모두 이렇게 철조망이 있었다고 합니다. 지금은 C동에만 원형 그대로의 철조망을 남겨놓았습니다. 철조망을 친 이유는 간단합니다. 어느 날 고문에 못 이긴 한 수감자가 이곳에서 투신을 했기 때문이죠. 크메르 루즈는 더 이상의 투신을 막기 위해 이렇게 촘촘하게 철조망을 쳤습니다. 수감자들의 인권이나 안전을 보호하기 위한 목적은 아니었습니다. 그들은 이곳에 잡혀온 사람들을 인민의 적, 그리고 기생충이라고 불렀습니다. 기생충들을 고문해서 원하는 답을 얻어내는 것이 그들의 목적이었습니다. 그런데 소위 기생충, 인민의 적이 자기가 가지고 있는 비밀을 다 털어놓기도 전에 투신해서 스스로 목숨을 끊는다는 건 크메르 루즈에게는 용납할 수 없는 일이었습니다. 철조망이 있어 투신을 해도 죽지 않는다는 것을 알면서도 몇몇 수감자들은 혹시나 철조망을 뚫고 아래로 추락해서 죽을 수 있지 않을까 하는 마음으로 몸을 던졌다고 합니다. 그 기록이 남아 있습니다. 철조망에 찢겨 숱한 상처가 난 몸으로 투신 기도자들은 더 혹독한 고문을 받았습니다. 개인 독방입니다. 과거에 교실이었던 곳에 벽돌로 방을 만들었습니다. 교실 벽돌을 뚫어서 소수의 간수들이 수많은 죄수들을 비교적 손쉽게 통제할 수 있도록 했습니다. 그래서 학교의 한쪽 교실 끝에서 저쪽 교실 끝까지 이렇게 문이 나 있습니다. 춘메이 씨는 자기가 생활했던 감방을 알려주었습니다. 바로 이곳입니다. 바닥에 있는 족쇄 그리고 변기통이 보입니다. 이곳 박물관에서는 춘메이 씨가 수감돼 있었다라는 표지를 걸어 놓았습니다. 관광객들은 이곳에 들어오면 갑자기 말이 없어집니다. 침묵하는 사람들 사이로 걸음을 옮깁니다. 감옥의 크기는 한 사람이 들어가 겨우 누울 수 있는 정도입니다. 몸을 좌우로 뒤척이는 것도 불가능했을 것 같습니다. 숫자를 모르던 어린 크메르 루즈가 벽에 파놓은 홈들입니다. 그리고 나중에는 아마도 숫자를 배워서 저렇게 숫자를 써놓았던 것 같습니다. 족쇄 열쇠와 방 열쇠가 걸려 있었던 곳이라고 합니다. 얼마나 좁았는지를 한번 살펴보시죠. 제가 들어가 누우면 양쪽 벽면에 몸이 꽉 낄 정도였습니다. 이곳은 햇빛도 제대로 들어오지 않았습니다. 고문을 당한 사람들의 피냄새, 그리고 오물 냄새, 온갖 벌레들, 상처를 보고 달려드는 구더기들로 이곳은 이미 살아있는 지옥일 것이었습니다. 수감자 중에는 그래도 햇볕을 볼 수 있는 방에 들어가 있는 사람들이 행복해 보였다는 증언을 합니다. 그러니까 이곳에서 많은 사람들은 햇볕도 보지 못하고 언제 어떻게 죽을지도 알지 못하고 언제 어디로 끌려가 얼마나 혹독한 고문을 당할지도 모르고 그렇게 희망이 없고 기약이 없는 나날들을 보냈습니다. 이곳 생존자들이 증언하는 이야기를 들으면서 저는 북한의 요독 수용소를 떠올렸습니다. 요독 수용소에서 탈출한 극소수의 사람들이 이런저런 증언을 한 것이 떠올랐습니다. 이곳 뚜얼슬랭은 인간이 만들어낸 최악의 고문시설, 수감시설이라고 사람들은 얘기합니다. 그러나 탈북자들이 들려주는 증언을 듣다 보면 이곳 수감자들의 증언은 차라리 인간적이라는 느낌이 들 정도입니다. 복도를 지나며 여러 가지 상념에 졌습니다. 2만여 명이 이곳에 끌려왔고 단 12명만, 그러니까 성인 7명과 어린이 5명만 살아남았다는 이곳. 괴롭습니다. C동과 D동 사이에 위령탑이 서 있습니다. 이곳에서 숨져간 수많은 사람들의 넋을 달래는 시설입니다. 불교식으로 지어진 위령탑에는 Never will we forget the crimes committed during the democratic Kampuchea regime 이라는 글귀가 새겨져 있습니다. 민주 캄푸치아 집권 시기에 저질러진 범죄들을 우리는 절대로 잊지 말자는 다짐입니다. 이것은 반인륜적, 반인류적, 반인권적 범죄입니다. 이와 비슷한 일들이 지금 북녘 땅에서 자행되고 있습니다. 그래서 저는 김씨 족속 집권 기간 중 북한에서 벌어졌던 일들을 우리도 절대로 잊어서는 안 되겠다는 다짐을 합니다.
영상 하나만 더 보고 마치겠습니다.
We have one last video to share. We've been seeing people dying here at this prison, and what happened was they were afraid of the contagion of diseases, so they decided to select a different site 11 kilometers away from S21, and that area was Cheong-aik. And this site is currently a genocide museum. But what I want to mention is that this execution ground actually are so many, and Cheong-aik is only one of the 300 mass execution sites across Cambodia, and currently there are only just some, or basically just Cheong-ai, where there's been excavation work on the remains and the remnants. So I would like to share that video.
모 공원 맨 안쪽에 있는 호수입니다. 이곳은 2000년에 조성한 인공 호수입니다. 홍수 때마다 이곳의 무덤이 물에 잠겼습니다. 그래서 더 이상은 무덤들이 물에 잠기지 않도록 이렇게 호수를 만들었습니다. 폴포트, 크메르 루주 지도자의 이름은 일종의 예명입니다. 폴리티컬 포텐셜에서 따온 이름이죠. 폴포트는 프랑스에서 공산당에 입당했습니다. 그리고 열렬한 모택동 숭배자였죠. 자신도 교사였으면서 모든 지식인을 혐오했습니다. 그래서 교육을 전혀 받지 못한, 그리고 사회 현상에 무지한 농촌 청년들을 징발해 자신의 전위대로 썼습니다. 청하이 대량 학살 센터에 있는 사색의 길입니다. 왼쪽으로는 수많은 봉분들이 있습니다. 그리고 오른쪽으로는 과수원이 펼쳐져 있습니다. 이곳 벤치에 앉아 이곳에서 숨져간 넋들을 기리며 인간이 어디까지 잔혹해질 수 있는지를 생각해 봅니다. 폴포트는 집권하자마자 화폐를 없애고 학교를 없앴습니다. 상업과 교육이 만악의 근원이라고 생각했으니까요. 그들이 꿈꿨던 것은 극단적인 원시 농촌 공동체였습니다. 호수 건너편 과수원입니다. 이곳은 청하이 대량 학살 센터 추모 공원의 경내 밖입니다. 하지만 이곳에는 아직도 발굴을 기다리고 있는 40여 기의 무덤이 있습니다. 모두 대량 학살의 흔적입니다. 무덤 하나하나에 얼마나 많은 사람들이 묻혀 있는지 아직은 모릅니다. 크메르루즈는 병원을 없애고 학교를 없애고 극장을 없애고 상점을 없애고 스포츠 경기장을 모두 허물었습니다. 그리고 사흘 만에 도시 자체를 텅 빈 유령의 공간으로 만들었습니다. 도시에 거주하는 사람들은 곧바로 집을 나와 농촌으로 이동해야 했습니다. 크메르루즈는 먹을 것도 주지 않고 교통수단도 제공하지 않고 그저 시골로 가라 라는 명령을 했죠. 길거리에서 수많은 사람들이 사망했습니다. 큰 비가 오면 호수가 있더라도 수많은 유골들 그리고 시신들에서 나온 헝겊 그러니까 사형수들이 입었던 옷가지들이 표면으로 떠오릅니다. 그래서 사람들은 이곳에서 아직까지도 처참한 대량 학살의 흔적을 마주합니다. 이곳에서는 추모객들의 동선을 제한합니다. 나무 데크를 만들고 그 위로만 다니도록 하는 것이죠. 데크 양옆으로 움푹 파인 구덩이들이 보입니다. 모두 대량 학살 당시에 쓰였던 무덤입니다. 구덩이 하나하나가 모두 5m 이상 깊이로 파여 있었다고 하죠. 관도 없이 아무렇게나 시신을 매장했기 때문에 시신에서 가스가 나왔습니다. 그리고 그 가스로 인해서 땅이 팽창했죠. 봉분처럼 솟아오른 것은 그 당시의 흔적입니다. 이곳 소년병들의 임무는 다음 사형 집행자들이 오기 전에 5m 이상의 깊이로 구덩이를 깊이 파는 것이었습니다. 군복을 입고 왔다 갔다 하는 소년병들은 그 자체가 위협적인 존재였을 것입니다. 그들은 인간으로서는 해서는 안 되는 짓을, 인간으로서는 해서는 안 되는 도구 사용법을 사형수들에게 시전했습니다. 이곳 청하익은 시설 전체가 슬픈 공간이지만 특별히 더 슬프고 더 서러운 곳이 있습니다. 바로 이 무덤입니다. 어머니들과 어린아이들이 함께 묻혀 있었던 곳입니다. 저 뒤로 보이는 나무가 킬링 트리입니다. 수많은 영유아들이 이곳에서 참혹하게 죽어갔다고 해서 붙여진 이름입니다. 크메르루즈는 어린 아기들의 발목을 잡고 아기들을 나무에 패대기 쳐서 살해했습니다. 때로는 아기들을 공중으로 집어던지고 칼이 달린 총으로 아이들을 받았습니다. 아이들은 비명도 지르지 못하고 온몸이 꿰뚫려 생명을 잃었습니다. 추모객들은 이곳에서 어린이들의 영혼을 달랩니다. 천국에 가라고 어린이들을 위한 색색의 고리를 나무에 답니다. 뚜얼슬랭의 책임자였던 비밀 감옥소장 끽아우는 자신의 범죄를 부인했습니다. 그러나 이곳에 와서 처음으로 눈물을 흘리며 잘못을 빌었다고 합니다. 나무 표면에 수많은 어린이들이 남긴 피부 조각, 뇌수 같은 크메르루주의 잘못을 변명할래야 변명할 수 없는 증거들이 너무나 많이 나왔기 때문입니다. 1980년부터 발굴을 시작한 희생자들의 뼈입니다. 추모공원에서는 이들의 뼈를 수집해 이렇게 추모객들과 만나게 하고 있습니다. 최근에 발굴된 뼈들은 아직 분류를 끝내지 못했습니다. 그래서 플라스틱 그릇에 뼈들을 담아 추모객들과 만나게 하고 있죠. 때로는 시신을 묶었던 쇠사슬, 철사, 노끈들이 함께 발굴되는 경우도 있습니다. 뼈의 주인공이 누군지는 모릅니다. 2000년대 들어 법의학 DNA 검사를 막 시작했지만 아직 모든 뼈들을 검사하지는 못했습니다. 이곳에서 나온 희생자들의 유골입니다. 1980년부터 발굴하고 수집하기 시작했습니다. 선진국 박물관에 비하면 전시 상태는 조금은 허름합니다. 하지만 이곳에서 워낙 많은 유골이 나오기 때문에 어떻게 할 수 없어 그래도 최선을 다한 그런 흔적인지는 모르겠습니다. 이곳 추모관에서는 사람들의 뼈는 뼈대로, 치아는 치아대로 나름대로 분류해서 전시를 하고 있습니다. 희생자들이 입었던 옷까지도 이렇게 따로 분류해서 전시를 합니다. 죽기 직전까지 입었던 옷, 죽기 직전에 벗겨진 옷, 구덩이 속에 시신과 함께 매장되었던 옷들입니다. 너무나 많은 시신과 너무나 많은 옷가지들이 나와 어떤 유품들은 전시품이 되지 못하고 이렇게 나무에 그대로 걸려 있습니다. 크메르루즈가 시신의 옷을 처형 장소에 그대로 두었다는 일화가 생각납니다. 그들은 그것을 처형의 증거로 생각했습니다. 희생자들의 치아만을 모아놓은 통입니다. 안내에 의하면 영구치뿐 아니라 유치도 상당수 섞여 있다고 합니다. 수많은 어린이들이 이곳에서 살해당했다는 명확한 증거입니다. 매직 트리, 마법의 나무라는 이름이 붙은 나무입니다. 수종은 보리수 나무입니다. 크메르루즈가 확성기를 걸고 혁명가요를 틀었던 그 나무입니다. 명분은 이웃 농촌의 혁명의식을 고양하고 농부들의 노동의식을 고취한다는 것이었습니다. 하지만 실상은 이곳 죄수들의 비명을 막고 어떤 일이 벌어졌는지를 위장하기 위한 것이었습니다. 크메르루즈는 밤에도 혁명가요를 틀었습니다. 이웃 주민들의 공포감을 극대화하려는 의도였습니다. 이웃 주민들은 밤에도 크메르 루주가 이곳에서 무언가를 하고 있구나, 뭔가 엄청난 일이 벌어지고 있구나 라는 것을 느꼈다고 합니다. 디젤류 발전기 소음이 섞인 노래는 아직도 남아 있습니다. 추모객들은 이 노래를 들을 수 있습니다. 사소한 것부터 사람들을 속인다는 사실, 전 세계 모든 공산주의자들의 공통인 것 같습니다.
네, 기회가 닿는다면 통일 후
So I do want to mention that after unification, I want to go to the political prison camps of the DPRK and show in video and archive the atrocities that happened. And I will continue on with my work for human rights. And with that, let me conclude my presentation. Thank you.
We'll now break for lunch. So could those of you with green lunch tickets please make your way to our staff by the entrance of the court, and they will show you to basement level 1 where you'll have lunch. Those of you with pink tickets, your lunch will be provided here after 10 minutes. So please feel free to take a 10-minute break before your food arrives. We will be starting again in 1 hour. So if you could come back before 1:25, so you can resume. Thank you. 지금부터 점심시간입니다. 녹색 점심 티켓을 가진 분들은 입구 쪽에 있는 저희 스태프들과 함께 점심 장소 지하 1층으로 이동하시기 바랍니다. 핑크색 티켓을 받으신 분들은 이곳 현장에서 10분 후에 도시락으로 식사를 제공해 드립니다. 10분 동안 쉬어셔도 됩니다. 1시간 후에 1시 25분 돌아오시면 됩니다. 감사합니다. starting the pre-trial at 1:30. Thank you. All rise, please. Please be seated.
Good afternoon, ladies and gentlemen. We, the pre-trial chamber of International Moot Tribunal, are prepared to deliver our oral ruling in the case of prosecutor versus Kim Jong-un, the supreme leader of DPRK. The final written report will follow, and thank you for your patience. Our decision reflects the thorough deliberations you have witnessed. Good afternoon, ladies and gentlemen. Thank you for your patience again as we deliberated. We are now prepared to present the oral ruling of the pre-trial chamber of the International Moot Tribunal in the matter of the prosecutor versus Kim Jong-un. This is a summary of our findings, which we will later finalize in writing, and which we will include our full reasoning. This case is about alleged crime against humanity in the Democratic People's Republic of Korea, or DPRK, under the Rome Statute. Before we begin, I want to underscore the gravity of these alleged crimes and the profound significance of these proceedings. The charges against the person charged are of the utmost seriousness, representing the most grave offenses under international criminal law. We also take a moment to acknowledge the victims of these alleged crimes. The testimonies and evidence presented paint a truly harrowing picture of human suffering and systematic abuse. Their voices have been heard, and their experience from the very foundation of our deliberations. I will mention procedural matters. We are here today to deliver the Chamber's decision following the hearing held in this courtroom on November 25th, yesterday, and 26th today. And in accordance with the Rome Statute and the tribunal's rules of procedure and evidence. Under Article 61(5) of the Rome Statute, the prosecutor must support each charge with sufficient evidence to establish substantial grounds to believe that the person committed the crime charged and may rely on documentary or summary evidence and need not call the witnesses expected to testify at trial. The purpose of this hearing was not to find the truth in relation to the guilt or innocence of the accused Kim Jong-un, but to confirm the charges on which the prosecutors intend to seek trial. In short, the confirmation of charges hearing exists to separate those cases and charges which should go to trial from those which should not. It serves to ensure the efficiency of the judicial proceedings and to protect the rights of persons by ensuring that cases and charges go to trial only when justified by sufficient evidences. We have carefully considered all evidence and argument presented by the prosecution and the defense counsel. After thorough deliberation, the Chamber has reached the following findings of fact and conclusions of law. I will mention the finding of fact. Based upon witness testimonies and documentary and summary evidence presented by the prosecutor, the Chamber finds as follows. 1, the person charged, Kim Jong-un, is supreme leader, commander-in-chief of North Korean Army, General Secretary of the Workers' Party of DPRK, and President of the State Affairs Commission. The prosecution has established that Kim Jong-un is the leader of government of which he has complete legal and de facto control across both military and civilian arms of government. 2, the political prison camps in the DPRK, known as 관리소, in Korean, 관리소, exist and remain in operation today, detaining an estimated 120,000 prisoners. Their existence and the scale and breadth of their operations is confirmed by the investigation undertaken by independent experts, including the UN Commission of Inquiry, UN Special Rapporteur on DPRK human rights, and UN High Commissioner on Human Rights, who have reviewed satellite imagery and witness testimonies, among other evidence. In addition, over the last 20 years, there have been dozens of resolutions adopted by the UN General Assembly, UN Human Rights Council, and former UN Commission on Human Rights, which have all acknowledged the existence of the political prisoner camp. While this resolution alone are of no specific evidentiary value because they are political statements, they do serve to reinforce the very widely acknowledged credibility of the aforementioned independent UN investigations. 3, individuals are detained in the political prisoner camps on the principle of guilt by association or 연좌제, consistent with Kim Il-sung's admonition that 3 generations of the inmate should be annihilated for many reasons, including North Korea's socio-political classification system, or 성분, officially categorizing individuals as a political prisoners. As a result of 토대, which is one's family's background, for example, persons whose parents or grandparents were connected with the Japanese occupation during World War II, or the South Korean Army, including the Korean War, or other actions perceived as determining the supreme leader's authority, including verbal treason, also known as 말반동, oral treason, 말반동, espionage, engaging in religious activities and attempt to flee to South Korea. Upon the government making a secret determination that the person should be detained in the political prisoners' camps, they are disappeared by the state, along with members of their family, and held incommunicado, and outside of any legal process. 4, the treatment of detainees in the political prisoner camps is very, very harsh. Camps are surrounded by high perimeter fences, electrified with deadly voltage, with pit traps and minefields also placed around the fence. Public and secret execution are carried out without legal process for reasons such as attempts to escape, violation of rules, or obedience of orders. Lesser offenses result in confinement, beatings, and mutilation. Detainees, including children, are assigned to demanding labor in mines and farms, often without rest, and are subject to beatings, extended hours, and food rations cut if they don't meet daily work quotas. Brutal and inhuman conditions, including malnutrition and starvation due to below subsistence level food rations, and almost no medical care. This system is designed to ensure large numbers of deaths in detention from starvation and disease. Women subject to forced abortion and additional punishment, including execution and torture, rape perpetrated by guards and prisoners in privileged positions, is common, very common. In short, the political prison camps are death camp. It's death camp, designed and operated by the DPRK to ensure the slow but inevitable death of their detainees. 5, the political prison camps are run by the Prisons Bureau of Ministry of State Security, 국가안전보위부, whose minister reports to Kim Jong-un through the State Affairs Commission, the supreme political authority in the DPRK, through the Korean Workers' Party and directory. In each opening and closing argument, defense argued that none of the 6 witnesses presented by the prosecution actually provided direct evidence of the crime against humanity being committed by the charged person, Kim Jong-un, in the political prison camps from when he became supreme leader in 2011. The chamber agrees with this conclusion, but emphasized that under the Rome Statute, the prosecution had no obligation to call all witnesses expected to testify at trial and may rely on credible documentary and summary evidence alone. The chamber's finding of fact in relation to Kim Jong-un's responsibility are grounded in that evidence. Now, the conclusion of law. The chamber finds that the prosecutor has provided sufficient evidence to establish substantial ground to believe that the person charged, Kim Jong-un, has committed the following crimes against humanity charged: murder, extermination, enslavement, imprisonment, torture, rape, and other sexual violence, persecution on political, religious, and gender ground, and enforced disappearance. The chamber finds as follows with respect to each of these sets of crime. 7.1, murder. The intentional killings of individual inmates in the prison camps through summary executions, beatings, infanticide, deliberate starvation, and other illegal means all amount to murder. This establishes the crime of murder under Article 7.1a of the Rome Statute. 2. Extermination. The intentional infliction of conditions of life calculated to exterminate a population include inter alia the deprivation of access to food and medicine and other conditions, for example, forced labor. This established the crime of extermination under Article 7.1b of the Rome Statute. 3. Enslavement. The experience of the prisoners in the political prison camps bear all the characteristics of enslavement, as inmates, often from a very young age, are subject to a lifetime of arduous and perilous forced labor, and rarely have the prospect of release. This established the crime of enslavement under Article 7.1c of the Rome Statute. For imprisonment, some 1,200,000 people are currently detained in political prison camps without have ever been charged, tried, convicted, or sentenced before a court of law for any crimes. This established the crime of imprisonment under Article 7.1e of the Rome Statute. 5. Torture. Physical torture is an established feature of the political prison camps. This established the crime of torture under Article 7.1f of the Rome Statute. 6. Rape and other sexual violence. Female inmates are raped using physical force, and in other cases, women are pressed into consensual sexual relations to avoid harsh labor, assignment, or to receive food. Forced abortions are also regularly committed in the political prison camps. This establishes the crime of rape and other sexual violence under Article 7.1g, 1 and 7.1g6 of the Rome Statute. 7. Persecution on political, religious, and gender ground. Such discrimination is widely reported, and this established the crime of enslavement under Article 7.1h of the Rome Statute. 8. Enforced disappearance. Prisoners detained in the political prison camps are typically disappeared by the state. This established the crime of enforced disappearance under Article 7.1i of the Rome Statute. In addition, the Chamber finds that the Kim Jong-un has command responsibility for these crimes against humanity committed in the political prison camps under Article 20B of the Rome Statute. Because the Minister of State Security report to him, he has effective command and control over the minister and ministry which runs the camp. He has failed to properly exercise control over the minister and ministry. He knew or should have known these crimes are being committed, and he failed to take necessary and reasonable measures to prevent or repress commission of crimes. To establish that crimes against humanity have been committed in this case, not only must evidence of the specific crimes be established, but they must be widespread, systematic, directed against a civilian population. And Kim Jong-un must have knowledge of these attacks. The operation of political prison camp is widespread and systematic because they detain an estimated 1,200,000 people and were established to achieve a central political objective, namely the elimination of 3 generations of enemies. The camp continued to serve this purpose, while also being used to purge from society anyone else who pose a threat to the political system and its leadership. The first labor derived from prisoners in the camp's mines, farms, and factories assist in the realization of key economic objectives. The inhuman acts perpetrated occur on a large scale and follows a regular pattern, giving rise to inference they are part of an overall state policy. In addition, the DPRK has devoted considerable resources to establishing and expanding its sprawling system of political prison camps. The Ministry of State Security, the country's elite security agency, 1, is responsible for guarding inmates and administering the camps. 2, an entire bureau is assigned to this task. 3, it is staffed by the thousands of agents and guards. And 4, roads and railroad connection have been built so that production taking place in the camps can be fully integrated into economy. It is impossible to believe that such a large scale and complex institutional system could be operated without being based on a state policy approved at the highest level, given the strongly centralized nature of the state in the DPRK. In terms of establishing that Kim Jong-un has knowledge of the political prison camps, there have been independent investigations conducted and reported open by the UN Commission of Inquiry, UN Special Rapporteur on DPRK Human Rights, and UN High Commissioner for Human Rights. Indeed, all these entities also reached out directly to the DPRK government, requesting access to the country and providing Kim Jong-un and his government the opportunity to review and respond to the alleged crime that have been committed. For these reasons, the Chamber hereby confirms that Kim Jong-un is criminally responsible within the meaning of Article 28B of the Rome Statute for all charges, and commit him to a trial chamber for trial on charges as conformed pursuant to Article 61(7)(8) of the statute. This concludes the summary of the Chamber's decision. This summary is an authoritative account of the Chamber's reasoning. The written decision will be made available to the participant and the public as soon as it is finalized. I will now give the floor to Judge Cartwright for any additions or clarifications or comment she wished to make.
Thank you, Judge Chu. I have no additions or amendments that I wish to make. I wish, however, to note that this is a significant first-time attempt to show the process that would occur if Kim Jong-un were to be charged with offences under the Rome Statute. It has given the opportunity to see how the process would work in reality, but it is a moot tribunal, and if it were to have been a real tribunal, the prosecution would have had different material to produce. Thank you. I'm sorry. The prosecution would have had perhaps different material to produce, different witnesses, different documents, and the defense would have had the advantage probably of a proper professional relationship with the person charged, and it would therefore have brought forth a different set of allegations, facts, and we might have made different findings. So, although it is an important exercise to show the reality of a trial, it cannot be relied on technically and legally. Nonetheless, I want to thank Peace Corps for making this, and its supporting agencies, for providing this opportunity to show how accountability against a senior leader in such egregious circumstances would be conducted calmly, fairly, and listening closely to both sides of the argument. I think it has been a very important first step, because accountability for crimes as profound and serious as the ones that have been alleged before this Moot tribunal is the most critical part of international criminal justice. They cannot be allowed to continue unchallenged. So thank you for the opportunity of being able to participate. For me personally, it has been a privilege and also a profound experience as I have read the evidence in preparation and as I have listened to the evidence of the survivors who've come before this Moot tribunal. And I want to thank them sincerely for that opportunity. That's all I wish to say. Thank you, Judge Chair.
Thank you, Judge Cartwright. Thank you for your meaningful comment and remarks. Thank you so much. And I'd like to give my final conclusion of this case. The Chamber's finding in this case undeniably grave. They reveal a systematic and widespread pattern of abuse by the DPRK regime against its own people. Kim Jong-un, as a supreme leader of DPRK, bears ultimate responsibility for these crimes. His actions and lack thereof have enabled and perpetuated a long-standing system of oppression and brutality. The Chamber's decision today is a step towards accountability. Its recognition of the suffering of the victims and call for justice to be served. Thank you so much. This concludes 2 years international Moot trial against humanity in the prison camp of DPRK. Thank you.
All rise, please.
That wasn't my question, that was his.
Thank you. Please be seated. Peace Corps and NKHRC Chairman Mr. Kim Tae-hoon will now give some closing remarks.
예, 이로써 이틀간에 걸
This brings us to the end of the two-day International Moot pre-trial on crimes against humanity in North Korea's political prison camps. I would like to extend my gratitude to the audience for staying with us till the very end, as well as for their attention. Throughout the 2 days, I do have to mention, while we had many human rights related events, typically on day one, especially during the morning session and after the commemorative photo, many would go back home. However, this was a different moment where we had the audience stay with us till the very end throughout the 2 days, listening attentively throughout the pre-trial proceedings, and I am very happy to see this. And they do say that, and there's a proverb in Korea that says that anything that once we do start, that would be half done. And I do believe that this is not a one-time event. As you all know, human rights issues in the North is quite complex, complicated, and of wide range. This time around, we've dealt with the crimes against humanity in the political prison camps. However, there are so many human rights violations. So if the circumstances allow, we will actively collect your feedback as well as your comments going forward. So I do want to mention that PS Corps, NKHRC, and Hanbyeon, we will be actively collecting your feedback, your comments, your views. Please give us more information on any rooms for improvement, what we need to do better, and also with regard to this international Moot pre-trial, how we should proceed in the future. So if you do give us your comments, we will make sure to put together an even better event. Once again, thank you all to the participants, and thank you to our prosecutors, Thank you to Jared Genser, Brian Tronick, Yonghin Lee, Hyun-Gi Kim, and James Cornell, and Marshall Amir. Thank you so much for being with us till the very end. Thank you.
예, 지금까지 모두
Well, thank you very much for your time. We're about to wrap up. And actually, we need your feedback for this conference.
설문 링크를 곧 보여드릴 예정입니다. 여기서 설문을 한번 해주시고
We'd like to ask you for your participation at the survey. So we have a link provided here for you.
Ask Leah to do it. Leah, Leah, we need that. Leah, Leah. 이게 로그인이 뭔가 필요한가 봅니다. 그래서
I believe we'll have to log in, so the link will be at the reception desk. So please scan the QR code, and it would be great if you can offer us with your feedback. Thank you.